Hey y'all, I'm AdaKay, and I must confess, I'm a trial junkie. I enjoy viewing trials as if I was the seated juror. So grab a cup of java, get comfy, and join me as we hop into court. And don't forget to comment, like, and most importantly, subscribe. And if you're really enjoying the channel, please join our membership. Good morning, everybody. How are you doing post-Halloween? I hope everybody had a good time. I left all my makeup here, so I couldn't get ready. Good morning, good morning, good morning. We are on Verdict Watch, still on Verdict Watch for the Melody Farris trial. I'm getting tongue twisted. And we still have the notorious Wall. So there we go. That's what we have there. However, we're going to hop on over to Trial TV Live. We absolutely love them. Let me see. There we go. We absolutely adore them. Good friends of mine, and we are going to look into the Georgia versus the Ibarra nursing student. Ooh, my hearing aids are hot. Ah, that's why. Nursing student murdered motions hearing. So we're going to switch over here. Let me get this up and going. And let me get me embiggened. And here we go. We still are on Verdict Watch.
All right.
While we do that,
All right. The Superior Court of Athens, Clark County, and Section. Honorable H. Patrick Hagel, presiding.
Be seated, please. Okay.
yes.
Would you mind stepping across the hall and telling Ms. Smith we're ready?
Sorry about that.
Okay. Just tell him if he wants to.
Good morning, everybody. I left my makeup here accidentally after yesterday, so I'm gonna have to do it here. Hello, morning, love. I know. I can't believe I left my makeup here. Oh,
We usually don't have this much activity on Friday morning, but we have a new juvenile court judge, associate judge being sworn in next door, which is a nice event. So she's got family and others there. So there's a lot of moving around.
that's a sweet thing. Being sworn in. You're at the cemetery, Ronnie? I'm so sorry, love. You're getting a makeup class by me.
I'll begin by swearing in Ms. Smith whenever you're ready and hooked up.
Yes, sir.
You swear that you will truthfully and accurately translate English to Spanish and Spanish to English to the best of your ability. So help you God.
I do, Your Honor, esmagar el mil más del license legalmente.
Thank you.
Yes, sir.
And that's
Do you all expect Mr. Donnelly?
Yes, Your Honor, we do. I'm sorry, Your Honor. We can begin without him.
Okay. You all ready?
Seems right, yes, sir.
Okay.
We're ready, Your Honor. I think both parties would like to start, if Your Honor doesn't have a preference with the motion to suppress. Should be a single witness issue, and then whatever the state wants to do next is fine.
Okay. You want to be heard?
Oh, that's right, Ronnie, forgive me. I didn't, the day just clicked. I haven't had coffee or nothing. I follow. My bad. I apologize.
Yes, we would prefer the motion to suppress.
I'm not
Okay.
awake yet, y'all.
So, and that is related primarily to the fingerprint evidence, is that correct?
No, Your Honor, the motion.
Cell phones.
Yes, Your Honor, cell phones.
Okay. So we've got that issue. We've got the Dahlberg matter on DNA that I understand that there's a motion to continue about that.
Yes, Your Honor.
I will go ahead and tell you, my intent would be to allow the state to go forward with their evidence, and we can address, and I'll hear more from Mr. Kirby about his motion to continue as well, if he wants to,
Yes,
but
Your
not
Honor.
now. Okay. I mean, I think I'm just kind of outlining the order
Yes, Your Honor.
here. And other than some other matters related to
Yeah, I think.
jury selection and the process about that, I was just going to sort of outline some of
me a minute
those
to click.
things.
I apologize.
I don't have, what else? What have I missed?
I think there's an argument on the fingerprint motion that needs to happen today.
Okay,
And then we did file a motion to particularize the witness list. I think that would fit well into the what Your Honor was talking about, logistics discussion.
okay. So we can begin with the witness that you wanted to call.
Yes, Your Honor. The defense calls Agent Jamie Hipkiss to the stand.
Is she outside?
Yes, Your Honor.
And Your Honor, and counsel, just for the benefit of you all and Madam Court Reporter, since this is a continuation of the motions, and I suspect when we argue, these motions will be referring to exhibits we used the last time, like Exhibit 9 and Exhibit 12. The state is just going to start their exhibit numbering at 31, because we left off at 30 last motions hearing, if that's acceptable to the court. I think it'll just make it cleaner when we go to argue.
Sounds fine.
Thank you, Your Honor. You can.
Do you want to just?
Judge, if I could just ask, just to make sure that these microphones are off. I know the last time we came in, they were on, and we were.
That's right.
Okay.
What you're going to need to do is when you need them to be off, because it affects other things, I think there's a button,
Okay.
but otherwise, for right now,
Yes,
they
sir.
need to pick you up. So,
I understand 100%. It is, but my fear is just picking up what's coming through there on the feed. So we would just ask that it be turned off.
okay. You may proceed.
Agent Hipkiss, would you raise your right hand? Do you solemnly swear that testimony you will give is the truth, the whole truth, and nothing but the truth?
I do.
Please take a seat.
Thank you.
Would you begin by stating and spelling your name for our court reporter?
Yes, ma'am. My name is Jamie. It's spelled Jamie. Last name is Hipkiss, Hipkiss.
And where are you employed, sir?
I'm employed as a special agent with the Federal Bureau of Investigation. I'm assigned to the office here in Athens.
Agent Hipkiss, does your duties sometimes involve helping in investigating criminal matters in the United States?
Yes.
Are you involved in the criminal investigation of Jose Ibarra?
Yes, I am.
And would you briefly outline just what sort of tasks you've been helping in that matter?
Yeah, so I'm assigned to the Middle Georgia Safe Streets Gang Task Force here in Athens. It's a task force comprised of FBI, GBI, Athens-Clarke County Police Department, as well as the Coney County Sheriff's Office and the Georgia Department of Corrections. And being a part of that task force, we oftentimes assist in violent crime investigations here in Athens and in Northeast Georgia. So in this particular situation, since this was a crime of violence, it was a murder that occurred here in Athens, we were asked to provide assistance.
And as one of the duties in providing assistance, did you assist with the review of information extracted from cellular devices?
Gabby.
Yes.
And are you familiar with the data that was extracted from phones believed to belong to Mr. Jose Ibarra?
Yes, I am.
Okay. I want to start by talking about the way you go about extracting a phone. You use a tool called Cellbrite, is that
We
correct?
honor him today.
That's correct. Our digital forensic examiner in this case did use that tool.
And can you briefly explain what Cellbrite is?
Yes, Cellbrite is a forensic tool. In this particular instance, it was Cellbrite Premium, which is a more advanced tool. We actually, for the FBI, we only have one in the state of Georgia. And that tool essentially gives the forensic examiner the ability, if a phone is locked, to be able to bypass, or what we call brute force, the phone in order to essentially crack the passcode and be able to access the data on the phone. Once that occurs, the tool then provides an image of the phone, which we then can review as part of the case team.
Are there other software available besides Cellbrite for doing this sort of task?
There are other vendors. Graykey, made by Magnet, is another one. But Cellbrite, I would say, is the most commonly used one. Particularly in this case, the two phones that were examined were Android phones. So Cellbrite Premium would be a better tool to use to download those phones.
And you mentioned Cellbrite Premium. Are there different versions of the Cellbrite software?
Yes, there's what they call like a Cellbrite UFED 4 PC, which is like the basic version. Then obviously Cellbrite Premium being the more advanced.
And what is the difference between the information that Cellbrite Premium can extract versus Cellbrite UFED 4 PC?
Since it's a premium version, of course, it has the ability to, if you have a password protected phone, it has a greater success rate of getting into the phone than for the basic version of Cellbrite, for instance. Additionally, because of the capabilities of more advanced technology, it has the ability to extract more data.
Okay. So help us a little bit with the terminology. When you extract a phone, what you get, you call your forensic image, is that right?
Yes, it's an image, or, you know, it's basically like a replica, as best as the tool can do, a replica of what's on the device.
And this image can have different kinds of data within it, depending on what kind of image you're looking for, right?
Yes.
Can you please explain? I understand there are 3 kinds of forensic images. Would you please explain those to us if you can?
I'm not sure what you're referencing.
Can you explain the difference between logical forensic images, file system forensic images, and physical forensic images?
Yes. As a case investor, I did not do the forensic examination on these particular phones. So, but I do have basic knowledge from a case investigator standpoint. So like a logical would be essentially like the least amount of data that you would be able to get from the phone. Full file system, which was done in this case, would be more data that you would be able to get from the phone. Okay. It's basically different levels of data that could be extracted from the phone.
And am I correct in saying that in this case, the data that was extracted was a physical image? So all the information that could be obtained?
I believe it's referred to as like a full file system, or file system extraction.
Okay. But you would agree with me that whatever the highest level of forensic extraction possible, that was the level used on these phones?
My understanding, and again, I did not do the download of the phone, so I'm relying on what I've been told by other members of our team, is that it was only capable of doing that particular type of download.
Okay. So when you use Cellbrite Premium to generate this physical extraction, is there a way to limit what data Cellbrite Premium will extract?
No, in a full file system, you're going to essentially image the entire phone. It's going to pull all the data that the tool can pull. So no.
Okay, so just to be clear, if you were wanting to limit the data by a date range, for example, Cellbrite Premium is not capable of doing that limitation. Is that fair to say?
Yes, on the first step. So basically, there's a 2-step process. The first step being the imaging of the phone by the tool, which is going to capture everything, right? From there, then we're going to put it into a reader, which allows the data to be parsed out. And then we, as the investigator, I'll get that data and I will filter it out at that point to the date range that's listed in the search warrant.
So I want to talk about now turning your attention to the particular extractions that were done on phones 1B7 and 1B8. We talked about this the last hearing that you were not present at, but just as a recap, is it fair to say 1B7 and 1B8 are the nicknames assigned to the phones believed to belong to Jose Ibarra?
Yes, that's correct. That those numbers are used by the FBI. That's its common protocol that we use to label our evidence. So yes, 1B7 and 1B8 are phones that we've attributed to Jose.
Okay. Your Honor, permission to approach the witness?
You may.
So Agent Hipkins, I just handed you a document. Can you take a moment to verify that this is a Cellbrite report for phone 1B7?
Yes, let me just review it for 1 second, please.
You're going into
Yes, it
the
is.
full
And you were given a copy of
2.5
this report in
days.
advance of today's hearing, is that right?
That's
2.5
correct.
days.
And
during this break.
this is a report that contains data extracted from phone 1B7 that predates January 1st of 2022.
That's correct.
Your Honor, at this time, defense would like to move Defense Exhibit 3 into evidence.
Any objection?
May I have a moment to question the witness, Your Honor?
Yes.
Special Agent Hipkiss, did you create this report?
No, I did not.
And do you
Oh,
know
he
who
called
created
6 hours, 59 minutes.
I do not. It was
I think
emailed
it's
me
been
to
longer
me this last week by the defense counsel, but I'm not sure who created the report.
Do you know if the person who created this report has any training in Cellbrite Reader and UFED Reader?
No, I do not.
Of the information that is in Defense Exhibit 3, when it was sent to you earlier this week, is that the first time you had seen some of the information that was extracted from the phone?
Yes, it is, because I was reviewing what with the date range that was in the scope of the warrant. So this is the first time that I've seen this data, yes.
That's all I have, Your Honor. I won't object to its submission, and we'll just argue it later.
3 submitted, defendants 3.
And just to follow up on those questions, Agent, you were able to verify that everything in this report was extracted from phone 1B7?
Yes, per your request, when it was emailed to me, I did look at the Cellbrite report, which I can verify is a Cellbrite report. And I looked at the data, and it appears to be consistent with the original Cellbrite Reader report that was created by our digital forensic examiner.
Okay. So let's talk about how we get to limited reports like this from a large cell phone extraction. So when Cellbrite extracts a physical image from a phone, it's a lot of data, right?
Yes.
And in this case, phone 1B7 had over 35 gigabytes of data, right?
I believe so, yes.
Did you ever, just for curiosity's sake, did you ever try to turn that into a PDF file with all the data on it?
No.
Would you-
I did, in the sense of when I reviewed the phone during the time frame listed in the warrant, I found evidence that I felt was pertinent. I tagged that as pertinent evidence that we were seizing, and I created a PDF report at that time, which I turned over to the prosecutor, which was ultimately turned over to you.
Would you be surprised to hear that if you made a PDF out of everything in the report would be over 87,000 pages?
I wouldn't be surprised. I mean, I've reviewed a lot of phones in my career, so I wouldn't be surprised by that.
So this report is just a sampling of certain kinds of data within this 87,000 page report that could be generated.
Yes.
Okay. And phone 1B8, there was a little bit less data. Would you agree to me that it had close to 13 gigabytes of data?
Yes, that sounds about right.
So it'd still be several thousand images or pages if it was in a PDF format.
Yes.
Okay. So you use, when you get this data, you have a tool called the Cellbrite Reader, which kind of helps you review and organize the data. Is that fair to say?
Yes.
And you, as a part of your discovery application in this case, or the state, you turned over that reader to the defense counsel. Is that fair to say?
Yes, our standard procedure in regards to the discovery process would be to turn over everything that was initially captured in that first phase that I explained. And that would give the defense team the opportunity to conduct their own independent review, which is what I did in this case.
Sure. And the reader is what allows us to filter evidence by parameters like dates. The reader you can plug dates into the reader and it sorts the data into the limited category that meets that criteria.
Yes, but I will say, based on my training experience and examining a lot of phones, the tool doesn't always capture the date and time. There are instances where there is no date and time. In that case, our standard procedure would be to further review that data to determine if it is within the scope of the warrant.
And in your review of phones 1B7 and 1B8, was there data like you just described that didn't have a date associated
Thank
with
you
it?
for hopping
Yes.
on.
And
Appreciate
did you
you.
review that data that didn't have a
Get you
date
good
associated with it?
sleep.
Yes, I did.
And were some of the images that didn't have a date associated with them later used in search warrant affidavits for further inspection of the phone?
Yes, and if I could just give an example of that whole process. So how I normally explain that would be a similar situation. If you're going to a residence to conduct a search warrant, say for a firearm, right? And we went inside the residence, and let's just say we went into the suspect's bedroom and we were searching anywhere a firearm could be hidden in the bedroom. If, for example, we went and there was a dresser in there and I pulled out a dresser drawer and there was clothing in there, the next logical step would be to move the clothing to see if the firearm's in there. In this
Thank you,
scenario, I equate
Ron.
that to
You
the
have
same
a-
because it does not capture a date and time in the Celebrate report. I feel I have the obligation to review it further to determine whether it is or isn't in the scope of the warrant. If it is, then of course, we would seize it. In this case, once I started to review it and I could not determine when it was captured, then we went back to this court, obtained another search warrant requesting to seize that particular information.
Understood. Your Honor, may I approach the witness of the defense exhibit 4?
Yes.
Thank you.
Take a moment to look over that report, let me know when you have had a chance to do so.
Yes, ma'am. Yes.
Is this a report extracted from phone 1B8, the other phone that was believed to belong to Mr. Ibarra?
Yes, it is.
And is this also a summary of the data on that phone that was extracted that predates January 1st of 2022?
Yes.
At this time, I move to enter Exhibit 4 into evidence.
A few questions. Same question. Special Agent Hitkiss, did you create the Celebrate report?
No, I did not.
Do you know who created Defense Exhibit 4?
No, I do not.
Do you know if the person who created Defense Exhibit 4 has any specialized training in Celebrate and Fed Reader?
No, I do not.
And the data, I think the words was, does it contain a summary of the data? Does it contain a summary of the data or is it the data?
Based on my review, per the defense's request, I try to replicate it. I believe it's all the data that was captured between January 1st, 2019 and December 31st, 2021.
So it's not a summary, it's all the data, correct?
Yes.
And when you reviewed 1B8, did you even see or capture this data and put it in your seizure report?
No, I did not.
Why did you not do that?
Because it wasn't in the scope of the warrant. I only seized, and I wrote a report following my review listing what we did as part of the review, and then I created a separate PDF document and also tagged in the Celebrate Reader the pertinent evidence that I felt was in the scope of the warrant, which I felt was the evidence that we actually seized.
So
Good
Defense
morning,
Exhibit
Kristen.
4, you believe was not within the scope of the warrant, correct?
Yes.
And you did not see Defense Exhibit 4 or that data until it was given to you by the defense attorney, is that correct?
No, and it was turned over to the defense as part of our normal discovery process.
Yeah, the whole extraction was turned over. to
Right,
you.
right.
My question is about this specific exhibit.
Yeah, no, I've
This
not
data-
seen it until the defense had emailed it to me.
That's all I have for the questions at this time, Your Honor.
Is there an objection to the
Not-
admissibility at this time?
Not for the admissibility, no.
Or is admitted?
And Agent, just like I asked on Exhibit 3, you were able to confirm that the data in Exhibit 4 was part of the extraction for phone 1B8.
Yes, based on my review, it appears to be the same data from the original report for 1B8.
Your Honor, permission to approach the witness with Defense Exhibit 1.
You may.
My hair is still wet, y'all.
Agent Hipkiss,
Don't
a
blow
few
dry
moments
it.
ago, we talked about a Cellbrite reader, and I just wanted you to briefly explain to us, what does it look like when you're looking at the reader that's kind of accessing the data of an extraction?
It will have like a line by line file data, I would say. Like, if the date and time is captured, it will list that. It will also list like file path, which will oftentimes tell us like what application was utilized to capture that particular data, whatever it may be, a photograph or a video or WhatsApp messages. There's going to be additional data in there that basically tell us what the source is.
Okay, and directing your attention to Exhibit 1, is this fair to say it looks like a screenshot of what a user of this reader report would see when they're looking at the data?
Yes.
And is this image displayed on Exhibit 1 and the data associated with it, are they part of the extraction from cell phone 1B7?
Yes.
At this time, defense moves to admit Exhibit 1 into evidence.
No objection.
Defendant's Exhibit 1 is admitted.
And Agent, the only question I want to ask you about this image, well, two questions. One, we heard last week that this image was that of a GBI agent. Does that appear to be accurate from your review of the image?
Yes.
And can you tell us what time this image was captured on the phone 1B7?
Yes, it was captured on February 23rd, 2024 at 9:20 and 25 seconds p.m., which appears to be in Eastern time, so local time. And it was captured using the Third Eye Intruder application.
And Third Eye Intruder application, what is that?
Based on my research, it's the first time I've encountered an investigation. It's essentially an application that one can install on their phone that if anybody manipulates their phone or swipes on the screen or inputs an improper passcode, that it would capture their photo.
And isn't it true that Third Eye Intruder takes a photo when someone's trying to enter the incorrect password?
Objection.
Well,
being-
I mean, he can
He
answer
just
yes or no
said
to that
it.
question, but I can rephrase.
I'll sustain the objection.
I would say I would answer that.
Let him answer. Let her ask the second.
Sorry, Agent. Can you just explain when, to your knowledge, Third Eye Intruder would take a photo?
You just said it.
It could take a photo when the passcode is, or the pattern lock, depending upon how the phone is set up, is entered. But I know from training experience and best practices of collecting a phone that the first thing that you want to do to preserve data on the phone would be to put it in airplane mode, which would require you typically on an Android phone to either swipe down or swipe up, which I would imagine, I didn't have personal involvement in this, but I would imagine that
I'm
would.
not asking to speculate, but to your knowledge, the application takes pictures, as you said, when someone is manipulating the phone. Is that fair to say?
Yes, when somebody has done something on the screen, and based on my research on it, it wouldn't necessarily be, it could be from other things other than putting in an improper code.
Okay.
It could be from swiping the screen.
And did you test that with Third Eye Intruder?
I did not personally.
Okay, so the last time we were in court, Agent, we learned that the phones, when they were seized, were stored in a Faraday bag. Could you briefly explain for us what a Faraday bag is?
Yes, Faraday bag is a forensic tool that's used to try to preserve the phone in the sense that it eliminates any cellular signal from reaching the phone. And so some law enforcement, there's varying models, some are more expensive than others, have access to these. And part of the best practice of collecting a cell phone would, one, be to, like I mentioned, put it in airplane mode, disable Bluetooth or Wi-Fi, and then put it into a Faraday bag. But we've discovered over time that the Faraday bag's not the 100% solution. That's why you take those other steps, such as putting it in airplane mode to try to preserve the phone.
And would the phone being put in airplane mode be something that was logged on the device as a device event?
Yes, it typically, if the tool would pull that data. But in this case, my understanding, and again, I was not involved in this, but my understanding was they were not able to put the phone in airplane mode unless the pattern was entered into the phone to unlock the phone.
Okay, Your Honor, permission to approach witness with defense exhibit 2.
No.
And Agent, you can launch the review report and let me know when you've done so.
Yes.
Agent, is this a report generated from data extracted from phone 1B7?
Yes, it is.
And what particular data is this report focused on?
It's focused on the device events.
And I know I used that term earlier. Would you please explain what we meant by device events?
Yes, that's as you stated earlier, the Celebrate collects various forms of data with the ability to filter by specific things such as device events or pictures or photos. In this case, you filtered between, or whoever created this report filtered between February 23rd, 2024, and February 27th, 2024 for just the device events, meaning what was the device doing during this time period.
Okay. At this time, Your Honor, defense would like to enter Defense Exhibit 2 into evidence.
Briefly, Your Honor. Special Agent Hipkiss, did you create Defense Exhibit 2?
No, I did not.
Do you know who created Defense Exhibit 2?
No, I do not.
And do you know if that person had any training in Celebrate UFED Reader when creating Defense Exhibit 2?
No.
All right, that's all I have for now, Your Honor. No objection.
2 is admitted.
So, Agent, I just want to highlight some of the device events in this report. We don't need to go through all of them, but before I do that, each device event, does it have a date associated with it?
I believe so, yes.
And does it also have a time associated with it?
Yes.
And when we see a time on this exhibit, it says UTC. Can you explain what that means?
Yes, that's universal time. So in comparison to Eastern Standard Time on February 22nd and 23rd of 2024, UTC time is 5 hours ahead of local time.
Okay. And so when we see timestamps on this report, is it fair to say we have to subtract 5 hours from it to figure out what it would have been in Eastern Central Time?
Yes.
Okay. Or Eastern Standard, excuse me.
Yes, ma'am.
Okay, so let's start on row 23, which is on page 3 of the report. This is an occasion when the phone was turned on. Is that right?
I don't believe so.
This is an occasion when the display of the phone was turned on.
I'm sorry, you said row 23?
Yes.
Yeah, according to the report, yes.
Okay, and what time is associated with that display being turned on?
6:30 and 2 seconds p.m. UTC time, which would translate to 1:30 p.m. local time on February 23rd, 2024.
And according to this report, when was the display turned off next?
It looks like
I'm going to object to the form of the question. She can read the data and have him read the data, but when she said the display was turned off, she is assuming that the display was turned off. She needs to read the data as it appears on the report.
Judge, I asked when the report said the display was turned off, so the agent can direct wherever in the document that would be.
If that is your question, I will allow it.
Your agent, when does this report say that the phone screen was then, or the display was then turned off?
at 6:30.
I think her objection is related to the phrase when, it indicates when the display was turned off.
Yes, sir.
I haven't seen it, so I don't know what it says. I think he's limited to testifying what the report says, not what could have caused that entry in the report.
Yes, Your Honor. I thought I asked that way, but I'm happy to rephrase. Agent, what does the report say about when the phone screen was turned off?
It says it was turned off at 6:36 and 9 seconds p.m. on UTC, which is 1:30:36 local time. I mean, based on my review, I could see that the source is Samsung Rubin data, and I am familiar with that. I don't believe, the way you're phrasing it, it sounds like you're phrasing it like somebody's actually turning the phone on and off. Like that's just the phone doing that, I believe. I don't believe it's somebody actually turning the screen on and turning the screen off.
Well, I didn't actually ask you about who was doing what, but let's talk about Samsung Rubin. What is that?
Samsung Rubin data is data that's specific to Android phones. And so Samsung Rubin data is essentially, it's the phone talking to itself. It's the phone constantly monitoring the state. And it's something that you opt in as the user of the phone from the time that you get the phone. And the purpose of that is for many reasons. One, it'll monitor your location. So if those of you that have smartphones notice when you get in your car in the morning, it says, hey, you got a 51-minute commute to work. That's the phone basically monitoring you in the background. It also is for ad targeting because it monitors where you go and strategically sends ads to your phone. And so it's basically the phone checking on itself in the current state that it's in.
Sure. And so the phone is recording what's happening to it, but you're telling me the app is just recording what's happening to it doesn't tell how the phone is being manipulated. It just says what's happening.
Yeah, for example, I mean, if you just want to go to line 17 and it says Wi-Fi state off, that's just saying that the state of the phone, the Wi-Fi is disabled. It's not saying like somebody came over at that very moment and turned the Wi-Fi off. It's just registering the state of the phone.
Understood. But back to what we were talking about, the state of the phone was registered to be on at 6:30 UTC, is that right? Row 23?
Yes,
And then you had mentioned that it appeared to be turned off, or the display was registered as off on 6:36 UTC.
yes.
Okay, so let's drop down again to row 25. What data does that information display?
It's 6:39 UTC or 1:39 local. It shows that the display is on again.
And then when does the report say the display is turned off?
Approximately 30 seconds later, so at 6:39 and 44 seconds UTC or 1:39 p.m. local.
Okay, row 27, what data does that row display?
It again says the display is on, and that's at 6:40 UTC or 1:40 p.m. local.
And when does the report indicate that display is turned off?
At 6:41 p.m. and 9 seconds UTC, 1:41 local.
All right, I'm going to skip a bunch of data that I don't think is very relevant for today, and I'm going to direct you to row 57 of the report.
Yes, ma'am.
Let me know when you get there.
I'm there.
What data does row 57 indicate according to the report?
It states that on February 23rd, 2024 at 8:45 and 45 seconds p.m. UTC or 3:45 p.m. local, the display is on.
And when, according to the report, does the display turn off?
It would have been a little, almost a minute later, so 8:46 and 20 seconds p.m. UTC.
Okay. And then row 59, what does that data display?
Again, it displays on February 23rd, 2024 at 8:50 UTC p.m. And that's 3:50 local.
And what occurs to the phone at that time?
The display is on.
Okay. And when is that display turned off?
At 8:51 p.m. UTC or 3:51 p.m. local.
Okay. Directing you to row 63, what data does that row display?
63 on February 23rd, 2024 at 8:52 p.m. UTC or 3:52 p.m. local, the display is on.
Okay. And when does the display turn off according to this report?
At 8:52 p.m. UTC or 3:52 local.
And then row 65?
Row 65, again, February 23rd, 9:35 p.m. UTC or 4:35 local time. It's on, the display is on.
And in an effort to shortcut the court's time here, Agent, is it fair to say throughout the document there are a few more instances where the display is registered as on?
Yes.
And are all those display on data followed by a display off data?
Yes, what I think would be normal.
All right, so I'm not going to make you go through all of the other ones on this document, but would you agree with me that over the next 2 days captured by the report that there are multiple of these?
Yeah, which I would think would be normal if the phone received a notification, the screen would turn on.
Well, just a moment, Agent. Isn't it supposed to be in airplane mode at this time?
Well, it wasn't in airplane mode because it couldn't be put in airplane mode, which means that and upon further review outside of what you have in your report, it was receiving incoming WhatsApp messages, which means that the Faraday bag essentially failed. So it did have some sort of signal.
So the Faraday bag failed.
That's what it appears to me. It appears it was getting some sort of signal because we weren't, or I say we as in law enforcement, weren't able to take all the necessary steps to preserve the data, that being put in airplane mode. It wasn't possible. We weren't able to disable Bluetooth or Wi-Fi. So it was only put in a Faraday bag. So we're automatically right off the bat eliminating one step of best practices of collecting that device by the virtue of the state of the phone.
Sure. And then
Y'all, I got a
is
treat
it also
for
possible
you.
the reason the phone is receiving data at certain times is because it's not in a
Documentary
Faraday bag?
reviews have been very kind.
When I received the device, it was in a Faraday bag. So what happened outside there, I wasn't with the phone until I received it on February 27th at about 10:15 in the morning.
My question is another explanation for why the phone was receiving data is another possible explanation that it was not in a Faraday bag?
I mean, it could not be in a Faraday bag. It could be in a Faraday bag,
So it's either
it could
in
be in a Faraday bag and receive data.
It was either in a faulty Faraday bag or it was not in a Faraday bag. Is that correct?
I don't want to say faulty. I mean, there's a lot. I mean, you literally would have to get the Faraday bag and use equipment to determine if it was 100, if it was working the way it was supposed to work. But like, what I want to emphasize is we are already eliminating one step of the process to preserve it and prevent a signal going in there because they could not put it in airplane mode.
Okay.
So that was not possible. So we're putting in a Faraday bag, but it's not in airplane mode. So, and when you put it in a Faraday bag, the phone, it's because it always wants to have the best signal, right? Like that's why we get phones. We want a phone that we can pick up and dial and it connects to whoever we're calling to. So when a phone is in Faraday bag, actually how that phone reacts is it works even harder to try to find a signal. So I wouldn't consider it unusual at all for there to be incoming data coming in when they couldn't put it in airplane mode.
But you did say earlier you thought that the Faraday bag had a flaw or a fault to it.
That could be one reason, yes. But without taking that particular Faraday bag and using other equipment and testing it, I can't say for certain.
Sure. Thank you, Agent. I have no further questions.
Thank you.
Special Agent Hipkiss, when you first picked up 1B7 and 1B8, where were they physically located?
At the University of Georgia Police Department.
Were they both in Faraday bags?
Yes, they were, and they were in their evidence storage room when I received them.
And what day did you pick them up?
On February 27th at February 27th, 2024, approximately 10:15 in the morning.
Did you or did the FBI or was there a warrant obtained for 1B7 and 1B8?
At the time that I collected the devices, yes, there was. We obtained a warrant from this court at approximately 9:35 in the morning.
On 27th day of February, 2024.
Yes, ma'am.
And after a warrant was signed, was that signed by Judge Stevens?
Yes, it was.
Okay, and he signed a warrant for 1B7, 1B8, and other devices as well, correct?
Yes, ma'am.
And after that warrant was signed by Judge Stevens, is that when the phone and the FBI attempted to extract data from the phone?
Yes.
When you picked up 1B7, what, if anything, did you do to 1B7?
I did. So it's important that the phone remained on as far as data preservation. So when I received the phone, I brought it back to our office here in Athens, and I opened the Faraday bag and I pressed the button on the side to ensure that it had remained powered on, which it did.
It had remained powered on.
Yes, ma'am.
And was the phone 1B7 locked or unlocked?
I couldn't tell because all I did essentially was hit the side button and it just lit the screen up. So I couldn't tell, but based on discussions with our law enforcement that were involved in the extraction process, I know that particular device was locked by a pattern lock.
Okay, and what is a pattern lock?
Pattern lock is common to Android phones. And so rather than type in a PIN of like a number, a numeric code, pattern lock will typically, like in this case, I believe it was a Z. So the user will type in some sort of pattern to unlock the device.
Okay. And you only knew it was a Z after the fact, correct?
Yes.
Okay. And that phone had to be what you call brute force, and I'm specifically talking about 1B7, had to be brute forced opened by a tool called Cellubrite Premium. Is that correct?
Yes, ma'am.
And it was Special Agent Candace Hunter with the FBI that was able to unlock that phone. Is that correct?
Yes, ma'am.
And the date that Special Agent Candace Hunter unlocked that phone was what day?
February 27th, after the search warrant was obtained.
So the same day, but after Judge Stevens signed the search warrant.
Yes.
Okay. And you can actually see that based on defense exhibits that were provided, correct? For example, you have defense 2 in front of you.
Yes.
So that we can see when whoever made these exhibits made them, it states when the date and time of the extraction of the device. Is that right?
Yes, it does.
And I just have defense exhibit 2 up. But it says 2/27/2024, correct?
Yes.
Okay. And why would the phone have to be brute forced?
Because we did not know the pattern lock code to access the device. So essentially the forensic tool had to do the work for us. So in essence, we plug it into this forensic tool and it tries all sorts of various passcodes in order to crack into the device. And the tool has the capability of, like, if you were to manually try to do that, for example, a lot of phones, if you enter the passcode incorrectly like 10 times or so, it'll lock you out of the phone. But in the case of this forensic tool, it allows the tool to keep trying variations of passcode without it locking the device.
So even if you or anyone else wanted to search the phone prior to Judge Stevens signing that search warrant, you would be unable to because you did not have the passcode for the phone. Is that correct?
Yes.
You could not open that phone. Is that correct?
Yes.
And no one could open that phone unless they had the passcode to it. Is that correct?
Yes.
And the only time that 1B7 was ever opened was when Candace Hunter was able to brute force the password on the 27th day of February, 2024. Is that correct?
Yes.
Defense Exhibit 2 is Rubin data, correct?
Yes.
And what is Rubin data in general terms?
Like, it's just a personalization data is what is commonly referred to. It's basically the phone tracking your movements and your activities on your phone to make the phone a better experience for you, essentially.
And is the phone talking to itself? Is that correct?
Yes.
And does Defense Exhibit 2 mean that you or anyone from the GBI or anyone in law enforcement was physically turning on and off this phone 1B7?
No.
Does it mean that?
No.
You obtained, in fact, 2 search warrants for 1B7. Is that correct?
Yes.
The first one you told us was on the 27th day of February. When was the second one?
On April 24th, 2024, we obtained a second search warrant for 1B7 and then also a second search warrant for 1B8.
And after obtaining a second search warrant for both phones, and just briefly, without being too specific, why did you obtain a second search warrant?
Good
We
morning,
believe
Mr.
we
Farrell. How are
found
you?
evidence of additional crimes. So because of that, we obtained, that was one of the reasons. And then again, upon my review of the data that didn't have any time or date stamp, I had to review that further to try to determine whether that fit into the scope of the warrant or not.
And so did you seek permission from Judge Stevens to, in fact, to do that?
Yes, when I went back with the second warrant, that was specific to 1B8. We went back to Judge Stevens and told him that there was data on there that we felt was relevant to the crimes under investigation. There was no date and time associated with this particular data, but we requested his permission to seize that data pursuant to that second search warrant.
Okay. And after you obtained both search warrants, did you then do a review and seizure report of the data from both 1B7 and 1B8?
Yes, on or about June 3rd, 2024 is when I created my review report and I attached, as we call it, a 1A attachment. It's essentially attachment to the report. I created a PDF for 1B7 of all the data that we seized that we felt was pertinent to the investigation within the scope of the warrant based on our review. And I did the same thing for 1B8.
Okay. May I approach the witness, Your Honor?
Yes.
That's what I hate about decorating. No way.
Do you recognize States 31?
I'm getting ready to do my
Yes, I
fall.
do.
What is it?
Down a little.
This is a thumb drive containing the reports I just referenced. So the review report for 1B7 along with the attachments, and then also the review report for 1B8 along the attachments. And I know this because I got my initials on it, previously reviewed.
I'm sorry, go ahead.
I previously reviewed it, so yes.
And in States Exhibit 31, the items of evidence that you seized out of 1B7 and 1B8.
Yes.
So you move to States Exhibit 31.
I would ask that, no objection, I would just ask that information not be published this time due to the news in the room.
Your Honor, we will seek to have the same order that we had last hearing to cover States Exhibit 31 as well.
And no objection.
And I just ask that when you take a break, that the court do a camera inspection of it and we'll present an order to the court for your consideration.
Very well. 31 is admitted.
Y'all, I've got some interesting stuff. The document fairies. have
When you created
stuff.
your
Some
review and
food.
seizure reports for 1B7 and 1B8, did you do so within the scope of the warrants that Judge Stevens signed?
Yes.
And did you limit your search to both 1B7 and 1B8 within date parameters that Judge Stevens set out in the warrant?
Yes.
How did you do so? Tell us.
So when I received the Celebrate reader file, I was able to go in and I was able to filter the data by the particular dates in the warrant, which on the original warrant, the date range was January 1st, 2022 to February 27th, 2024, when the warrant was authorized.
And were there two different ranges, one for 1B7 and 1B8?
The original warrant was the same. When we obtained the second warrant, we narrowed the scope down as far as the date range even further. So for 1B7, we narrowed it down on the second warrant to, I believe, September 1st, 2023 to the date of warrant, the date and time the warrant was authorized. And then on 1B8, we narrowed it down to September 2023, I believe. I'm not 100%. I'd have to look at the warrant.
Okay, that's all right.
But it was narrowed down to a condensed date range.
And you use those date ranges to narrow your search of the phone when you were looking through the phone and complying with the warrant. Is that correct?
Yes.
So let's talk about data that has no date range. First of all, how can data in a cell phone have no date range?
A lot of times when we see that, it's been deleted data that's been recovered by the forensic tool. It doesn't have a date or time stamp. Additionally, when we have to use the technique that I described for 1B7 of brute forcing the phone, a lot of times it won't capture a date or time stamp for data when we do that process as well.
And so why is it that you look at data that doesn't have a date range when you're trying to stay within the date range that the judge put in the warrant?
Because it could be in the date range. So a lot of times when we see, I mean, essentially, like if people deleted stuff from their phone, then that would basically give them a free pass. You know what I mean? If it was in the date range and they deleted it, if we didn't review that further to determine when it occurred, then people could just delete stuff from their phone and we would never be able to use that evidence. But in this particular case and in other cases, when we look at it further, you know, I'll just use the example of like a text message communication that had been deleted. I can look at that data further and I can see that it fits in with other communications that occurred within the date range of the warrant. So I feel like I have to do a further review in order to determine the source of that.
And is that what you did in this particular review of both phones?
Yes, and then of course, if for some reason I was able to determine that the data was captured outside of the scope of the search warrant, then we wouldn't seize that data.
But you have to look at data that has no date on it in order to determine whether it's within the scope of the warrant or outside the scope of the warrant. Is that correct?
Yes.
And in searching 1B7 and 1B8, did you stay within the confines of the scopes of those warrants?
Yes.
Now, why is it, Special Agent Hipkiss, that when Cellubrite Premium had to brute force this phone, why couldn't you just tell Cellubrite Premium, well, just give us these dates in the phone? Why can't you do that? Why do you have to extract the entire phone and then subsequently search it?
That's the way the tool is set up. You know, I don't know the reasoning behind that. I mean, obviously, like an engineer who designed the tool would have to answer that. But you know, we can only review what we receive, and in a lot of times, the tool doesn't have the capability of extracting the date and time or determining when that particular event occurred.
And when the phone is physically extracted and the phone is completely downloaded, you said you give a copy of that to the defense so that they can have the entire phone should they want to do things with it, like create defense exhibits 1 through 4, for example, correct? Yes,
We actually state that in the warrant. In essence, on the last page of the warrant, it states that we will provide a complete copy of the data that was imaged to the government for independent review, which would then obviously be turned over to the defense.
Right. And I know exactly what you're talking about. Hold on a second. 2 things. May I approach the witness, Your Honor?
Yes.
I'm going to hand you what's already been admitted as State's Exhibit 9 from last hearing. And on page 13 of State's Exhibit 9, I want you to read silently to yourself the highlighted part. I'm going to ask you a question. Have you read it?
Yes.
Does State's Exhibit 9 and did Judge Stevens authorize you to do exactly what was done in this case, which is download the entire phone?
Yes.
All right, and can you read to us the pertinent language that you believe authorized you to download the entire phone?
Yes, it states nature of examination based on the foregoing and consistent with Rule 41 E2B, which is a federal rule, which I'm familiar with, which essentially states that we have the authority to execute the warrant outside the hours of 6 and 10 since it's a device in our possession. Additionally, it gives us the authority to extract the contents through the phone and review it at a later date. Following that code section, it goes on to state the warrant I'm applying for would permit the examination of the device consistent with the warrant. The examination may require authorities to employ techniques, including but not limited to computer-aided scans of the entire medium that might expose many parts of the device to human inspection to determine whether it is evidence described by the warrant.
And go to page 13 of the warrant. States Exhibit 9 again for the record.
I'm sorry, what
I'm
page?
sorry, may I approach you in your name?
Yes.
Yeah, I have that page. You're wrong, 13, 17.
Okay.
Which is actually.
That's
the
what
warrant
happens when I do my makeup
telling us that the
in the
warrant
room I'm
authorizes
working
you to
in
make
because I left.
entire copies of the phone.
Nobody-
Page 17, you see the highlighted portions? Read
Yes.
yours. Is that what you were referring
Go
to?
back and watch.
Yes.
Could you read that to the court, please?
The review of this electronic data may be conducted by any government personnel assisting in the investigation, who may include, in addition to law enforcement officers and agents, attorneys for the government, attorney support staff, and technical experts. Pursuant to this warrant, the FBI may deliver a complete copy of the seized or copied electronic data to the custody and control of attorneys for the government and their support staff for their independent review.
And so did you comply with all three of Judge Stevens's warrants in searching these two phones?
Yes.
I want to ask you finally about Defense Exhibit 1. The Third Eye capture app. First of all, it's like an anti-theft app, you told us, right?
Yes.
Okay, so does that mean that Defense Exhibit 1, that agent, for example, searched searched 1B7, that phone?
No, I don't believe it does.
And why not?
I believe that he was probably trying to put it in airplane mode, and that's what generated the phone to take the selfie image.
Your Honor, I'm going to object to lack of personal knowledge. This witness already testified he was not there at the time, so having him speculate about what was happening is inappropriate.
Sustain the objection.
I'll call the witness next. He's right outside. And I think that's all I have for this witness. Thank you, Your Honor.
Anything else, Ms. Brown?
Yes, Agent Hipkins, I'm working with my own copy of the search warrant, so forgive me if it has a numbering system different than yours.
Yes.
But the language you were reading from was from the affidavit attached to the search warrant, right?
Some of the language I read, yes, the nature of the examination, that was part of the application and affidavit that was presented to the judge. The last language that I read was one of the last paragraphs on the actual search warrant.
Did anywhere in in the order, it doesn't actually talk about the full extraction that you read from the affidavit. Is that fair to say?
No, it's in the application and affidavit.
Okay. The actual order does indicate that the data is to be limited to a certain date range, right?
Yeah, it said based on the evidence we could see is limited to a certain date range. That's correct.
Did anywhere in the affidavit for States Exhibit 9 or subsequent to the States Exhibit 9, did anywhere in the affidavit spell out for the judge that we don't actually have the capacity to limit our extraction of the phone, the date range we proposed?
I don't believe that. I don't know. Is this States Exhibit 9 that the prosecution has handed me, or?
Is that the 10? I'll come back.
Yeah, I prefer to look at what you're referring to.
Are you looking at, which one are you looking at?
I was looking at Exhibit 9, States Exhibit 9.
I'm sorry if you don't mind repeating the question too.
Sure. Are you aware of anywhere in States Exhibit 9 where the government tells the judge that there is no way to limit the extraction to the date range authorized by the warrant.
No, but I believe we tell, based on my interpretation of the warrant,
Well, I'm not asking for interpretation. You just, in this affidavit, you never tell the court that you cannot limit your search of the phone as the date range would apply.
but no, based on my involvement, I'm relying on the warrant. And so I have to have my own interpretation of the warrant in order to do my part of the investigation. So upon my review, it essentially states that we could search all 10 devices and that then we could seize what's related to the crimes in that date range. So the way that I interpret it is that the judge has given us the authority to search the entirety of all 10 devices, but we only have the authority to seize what is within the scope of the warrant within that date range as it relates to the crimes under investigation.
This is a warrant for search and seizure, yes?
Yes.
So this warrant limits your ability to search as well as seize, yes?
Objection, leading.
Sustained.
Agent Hipkiss, I am just asking for an answer to my question. Anywhere in this affidavit, do you say to the judge, we cannot extract the data within the date range you gave us?
I don't believe so, but
Okay, no
I mean, I would have to review the warrant in its entirety to be certain.
Special Agent Hipkiss, how can you, so let me go back to the. Oh, thank you. How can you seize items within the scope of the warrant if you can't search through the phone?
Yeah, and to elaborate on that, you know, if we didn't have we needed the forensic tool, obviously, to extract the data because it was password protected. But like if this phone, like 1B8, for example, wasn't password protected, like we would have to, the alternative is hand searching the phone, which means I would have to search everything. There's no way for me to figure out the date range without searching through the whole phone. It's not parsed out like it is in the Celebrite reader. So I don't understand. It doesn't seem possible to do what she's stating.
Okay, that's all I have.
Any other questions, Ms. Beck?
No, Your Honor.
You need to excuse?
Yes, Your Honor.
Any objection?
No, Your Honor.
You're excused.
Thanks, Your
Anything else on this issue,
Not from my side, Your Honor.
Ms. Ross?
State calls Special Agent Cameron Karate.
Sorry, guys. I know we have a verdict. Yep. Where it's not showing verdict yet. All right, here we go. And I have a Sarah Boone live that we're going live. Okay, guys, we have a verdict. Woohoo! Well, do we have a verdict or we hung? That's what I want to know. And I'm going to change the time on this Sarah Boone live to 10:30, well, 10:45. Because we got exclusive Boone documents, y'all, that just hit. My sound is up. Everything's up. We're waiting for them. Good morning, good morning, good morning. We have news. Are we sure it's a verdict? Or is it questions? It looks like a question from the jury. And it's long, so it looks like it may be
All right, can we have the legal definition of each charge as included in the indictment? That's what happened in my last trial. They asked for that, and then they asked for them again. And then I broke down and gave them in writing. Of the things that I have in writing, that's probably the thing I'm most comfortable with. But y'all can tell me how you want to do it, whether we want to read it to them and give it to them in writing, or just read it to them and wait for them to ask the second time before I give it to them in writing.
He's like, I already know what I want to do, but let's see if you go along with
What?
me.
What I discovered,
Best just to give it to him.
3 trials ago, was then they had someone trying to speed write while I was reading and writing it off the thing.
If you want to break out the charge and be like, here's malice murder
Right.
charge, here's assault
Right.
charge, that's fine. Just send it to them.
In writing.
Just give them the charge.
Yes, I'm okay with that. I'm okay with that.
Do y'all want me to bring them in to do that, or you just want me to print it out and give it to y'all and let y'all look at it and give it to them?
I think print it out. It's the same version you've got.
Oh,
All right. Oh,
Just give it to them.
but we'll see, actually, I gave y'all a printed one. Do I have?
she's comfy today. She's in a
I
sweatshirt.
think one of y'all gave me a printed one.
I had your version before your final version. You did a change.
Let me see what we got.
Thank God we don't have a hung. We're not hung yet.
You removed, I think simple assault's what you removed.
Well, personally, I'd give it to him. We don't know, y'all. What do y'all think? Give it to him or read it and have him take notes?
I think, like I said, my last trial, they wanted to walk through each instruction with the indictment as they were going through.
This is not a verdict. This is a question. They are wanting a copy, I think, of the charges, if I'm correct. Or they want more information on the charges, I believe. I think the charges are what's confusing them. This is not a verdict. This is a jury question. Dag nabbit. They're not hung. So yes, they're arguing, they're discussing, they're going back and forth. So we've not reached an impasse. So yeah. Oh, just for those who don't know, we were watching the Georgia versus Ibarra nursing student murder trial motions hearing. But we will be going live, depending on what time this is. Prison hoodies. No, but I do have, thanks to our document fairies, some documents that very few people have on Boone, and we will be going live either 10:30, well, not 10:30 because of this. I thought it was, so we're going to switch it back to 12. I'm trying to find a window to go live. We're going to switch it back to 12. Save that change. And we are going to be, it's going to be a separate live. I'll keep this stream up on the side and it will be a separate live and y'all can hop on over to both. And then when we get the verdict in, Yeah. I'd rather deal Christmas decorations than be, yep, me too. I got to get my house in order. I still got homework I haven't done. I got to find time sometime today to write 2 papers. So we'll see how this stuff goes. This is just too, can't. I can get it done, y'all. Don't worry about it. He looks so bored. Oh, poor baby. Be right back. Not very many people there. We don't have volume on their end, not our end. We want to know. Be right back. Okay, so they're going to give it to them in a written form. Okay. That judge with his robe cracks me up. Oh, I got to explain this. Somebody says, why do I, my hearing aids, sometimes I get a hair off my head and I'll put my hearing aids in. The hair goes in with it and it tickles and irritates. And I got to get it out. It's like, because my hair's long. Oh, I need to get groceries. We have nothing here at the shop to eat. I am so hungry. Look at that little... He flipped it like the robe of Queen Elizabeth. Did y'all see that flip? Let's watch that beautiful flip again. That was priceless. Watch that again. 1, 2, 3. Sorry, not sorry. And not sorry. Boy, he can do the robe flip well. And then plop. I know, it doesn't take much to entertain me here. It sure in the heck doesn't. But that was good. I have no idea, y'all. Typical man playing with a beard. He's my fun favorite, but the best judge was the Sarah Boone trial. He was brilliant. Yes, Jesus has been there every day. He's a reporter or book author or something. He's always just a writing. Is that kitty cat chasing you and you come over here for comfort? Is that what that is? You need some comfort. My puppers. She might be needing Jesus. Well, they're just chatting right now. Well, baby girl. It's too early to go home. We just got here. She did not want to get in the car today. My dog is like, I ain't listening. Okay, we're going to go back over to this other trial. This may or may not be something we cover. That's why I'm listening to it and trying to see if it's something we want to cover. So let's go back over to this. Oh, they changed their thing. Okay.
Today, in the matter of the state of Georgia versus Jose Ibarra will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Please take a seat. Spell your first and last name for Madam Court Reporter.
My name is Cameron Karate. That's Cameron. Last name Corradi.
Where do you work?
For the Georgia Bureau of Investigation.
What do you do for them?
I'm assigned to the Appalachian Regional Drug Enforcement Office, primarily tasked with investigating narcotics.
Are you a post-certified law enforcement officer?
I am.
Were you assisting the Georgia Bureau of Investigation, the Athens-Clarke County Police Department, and the University of Georgia Police Department in the investigation into the murder of Laken Riley in February of 2024?
Yes.
And pursuant to your assistance, did you find yourself at the defendant's apartment on February 23rd of 2024?
Yes.
Did you assist agents there in collecting cell phones?
Yes, I did.
I want to ask you specifically about two cell phones that were identified to you by a resident of the apartment. Her name was Rose Belly. Do you remember her?
Yes, ma'am.
And did she identify two phones to you?
Yes.
And did she identify two phones that she said belonged to Jose Ibarra?
Correct.
Did you seize those two phones?
Yes.
I want to talk to you about your seizure of both of those phones. First of all, were they Samsungs or were they Apples or what were they?
They were Android devices, yes. So they would be Samsungs.
When you seized those phones, did you attempt to keep them powered on and put them in airplane mode?
Yes, I did.
Why do you do that?
We do that to preserve potential evidence that may be stored within those particular devices or any device in reference to the crime being investigated.
Could you, why does putting them in airplane mode do that?
Because devices can be remotely wiped by any individual that has access to do that to that particular device.
So putting in an airplane mode can prevent that?
Yes.
One of the particular phones was passcode protected. Do you remember that?
Yes.
And did you attempt to put that passcode protected phone into airplane mode?
Yes.
How did you do so?
For Android devices, typically, I believe you have to swipe up from the bottom of the device in order to activate the lock feature, which in this case, typically Android phones have a pattern lock as their password. So I would have swiped up to activate the pattern lock and then attempt to put the pattern lock that was provided to unlock that phone.
And who provided you a pattern lock?
That would be Ross Belly, Flores Bayo.
And the pattern lock that she gave you, did it work?
It did not.
Did it unlock the phone?
No, it did not.
Were you able to unlock that phone?
No, I was not.
Were you able to put that phone in airplane mode?
No,
Did you search that phone?
I did not.
And when you left there, did you leave the phone with special agents at the GBI?
Yes.
Same question with the other phone of Jose Ibarra's. Did you search that phone that night?
No, I did not.
That's all I have, Your Honor.
Questions?
Yes, good morning.
Good morning.
Do you own an Android phone yourself by any chance?
I have in the past. I do not know.
Okay, and I have two at one time. My sister does now. Is it true that you can actually put phones in airplane mode without unlocking them?
It depends on the device.
But there are certain devices that can. You can put them in airplane mode without trying to get into it.
Sure.
And you do that by swiping down from the top and hitting the airplane symbol.
Sure.
Did you try to do that with this device?
Yes.
And what happened?
I believed it wanted me to put in a password to unlock the phone to put it in airplane mode.
So it would not let you put it in airplane mode from the lock screen.
No, it did not.
So then you attempted to get into the phone
Yes.
and you attempted to use a pattern to unlock it.
Yes.
And that pattern was provided to you by Rose Bailey.
Yes.
Rose Bailey was not the owner of the phone.
No.
You did not have permission to go into the phone.
No,
No further questions.
Did you go into the phone?
I did not.
Thank you.
Anything else?
No, Your Honor.
Be excused.
Yes.
Thank you.
One more briefly. Special Agent Candace Hunter.
Candace Hunter, Special Agent.
Matt? Wow, guys, we just had a big bang here. Don't know what it was. Show us the puppy.
Raise your right hand, please. Do you swear from the testimony you will give today in the matter of the state of Georgia versus Jose Ibarra is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Please take a seat. State your name, spell your first and last name, please.
Candace
Uh-oh.
Hunter, CANDACEHUNTER.
We switched the view.
Where do you work?
I work for the FBI in Atlanta.
Good morning.
What is your title?
Uh-oh.
I'm a special
We got action. Dun 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 dun. Oh, why are we showing that? And your camera is off kilter. Get it straight. As a professional ex-photographer, that's driving me back crazy. I can't do it. I can't do it. I can't. Y'all. I've never been diagnosed with ADD or ADHD or anything like that, but that right there I can't. I have to look at something else, y'all. I can't. What are y'all doing? They got the microphone plugged in. Maybe we have a verdict. Maybe we have a verdict. I need to find a way, y'all, and maybe y'all can help me with this, that I can, like, warn a situation like this and we have a verdict, that I can do a quick broadcast out there and get more people to hop on, inform them that there's a verdict. Verdict is in. With all my subscribers, all my members. How do I do that? Why are you playing with the freaking camera live? Don't do this to me. Arr. Okay.
digital forensic examiner.
How did you obtain that certification and how long have you been a digital forensic examiner?
I've been a forensic examiner since 2008. And the certification process is about a 2-year process of training, different trainings, both through the Bureau, through vendors, and different agencies.
Are you familiar with Cellebrite Premium?
Yes.
Could you tell us how you're familiar with that product?
We acquired a premium in 2021 in Atlanta to utilize to get into we use it for both platforms now, but into locked phones, both Androids and sometimes occasionally Apple devices as well.
And how many times do you think you have had the opportunity to place a phone on Cellebrite Premium and extract data from that phone?
Approximately 100.
I want to ask you specifically about 2 phones that came to you to be extracted in the case of State of Georgia versus Jose Ibarra. And those were phones that were labeled by your agency, the FBI, as 1B7 and 1B8. Are you familiar with those phones?
I am.
I want to specifically ask you about 1B7. When did 1B7 come to you for extraction?
It came to me on February the 27th, that afternoon.
When you received 1B7, was it locked or unlocked?
It was locked.
What type of phone was 1B7?
It was a Samsung A14.
What kind of lock did 1B7 have?
A pattern lock.
So with 1B7 being locked, could you have searched the phone without Cellebrite Premium?
No.
Why not?
I couldn't get into the device without having some tool to guess the pattern lock to unlock the device. So there was no way to get into the specimen without using Cellebrite Premium. There are other tools on the market, such as GrayKey, but we did not have an Android license for the GrayKey. So the only option I had was Cellebrite Premium.
Was the phone in airplane mode?
No, it was not. I tried to put it in airplane mode upon receipt, but some phones will not allow you to put them in airplane mode if they are locked. And this particular one would not allow me to place it in airplane mode.
So how did you go about extracting data from 1B7?
So first, what I did is I removed the SIM card from the specimen, and I extracted the SIM card in order to obtain the associated phone number for that device. And then I took the phone itself and attached it to the premium for it to attempt to break into the phone.
And did you do these things only after receiving a search warrant to extract data from the phone?
Correct. I met the individual that brought the phones to evidence, I believe around 3 o'clock that day, and they came with the warrant. So I was able to review the warrant prior to.
And when you say break into the phone, what do you mean by that? What happens?
So the software, it has different ways of doing it, and you would have to speak to someone specifically from Celebrate Premium to tell you exactly how it does it, but it guesses different patterns and different, if it was a passcode, it would guess different passcodes without, like if you just physically did it, there's sometimes you will hit a max password of, oh, you've attempted 3 times, now you have to wait a certain number of times. The software is able to defeat that. So it's able to guess more than just, let's say 3 times, to guess different passcodes to see if it can get into the device.
When, was Celebrate Premium able to get into the device?
Yes.
And were you able to do an extraction of the phone?
Yes.
When you are extracting data from 1B7, you read the judge's search warrant.
Yes.
Is that right? Told us. Can you tell Celebrate Premium, I only want you to extract this date range from this phone. Don't extract anything else from the phone. Can you do that?
I know.
No, it's a full file system extraction that's obtained from the phone.
Why is that?
Because that's the most complete extraction that we can get, and then the agent or the investigative team can do their review that's pertinent to the warrant to select the items that are relevant.
And may I approach the witness, Your Honor?
Yes.
I am handing you, it may already be up there. Do you see Defense Exhibit 2?
I don't see any exhibits.
I'll give you my copy. Oh, thank you. It's probably better to do it there. Yes, Defense Exhibit 2. First of all, do you know what movement data is?
Yes,
What is it?
it is basically Samsung's internal information that they are using to keep track of the device itself. So it keeps all kinds of data about the device in order to make it a better user experience for the user. So Apple also has this. Some people are familiar with the Knowledge C database. So it's similar to that if you're more accustomed to Apple products.
Can you go to page 3 of Defense Exhibit 2?
We are watching.
Sorry, wait. Defense Exhibit 2, page
Manicured.
3. And do you see line 23?
Yes.
Okay. And that's just, it says display on, off.
Brain
on.
dead.
Does that mean that someone was physically touching the phone and turning the phone on and off?
Not necessarily.
Nursing
It's
home,
definitely
I'm
not
sorry.
turning the phone
Georgia
on and off. It's
versus
the display
Ibarra.
coming on and off.
Nursing
But
student
there are
murder
many
trial.
things that would
Motion
cause the
hearing.
display to come on and off. One could be a user picking up and lifting. So you can set the settings in a phone to
Reading for the jury.
awake and the display to come on when you lift it. You can set it to just like the screen to flash, or even a sound to come on when you get a certain type of notification. Those are all customizable features that the user can set in the settings, but it does not necessarily mean that the actual person was moving the phone or anything.
What else could cause a display to come on?
Other than lifting it up and notifications and
So if you have received a notification, like a WhatsApp notification.
yeah, any notifications, you can set it to come on just with anytime you receive an email or anything like that.
And since 1B7 was not in airplane mode, would it still be able to communicate with the tower? Or,
Yes, well, in this case, it did come in a Faraday bag, which is our way of trying to prevent that. And we do try to put it in airplane mode so that we do try to prevent that. But it also came attached to a charging device, which almost acts like an antenna. So even though you're trying to prevent it, which is the best that we can do, it still could potentially communicate with the tower. So, and
go ahead.
I'm sorry. And then that's why also I went ahead and removed that SIM card to either try to attempt further to prevent those tower communications when I hooked it up to the premium.
And so every time that we see in defense exhibit 2 this Rubin data, that is also could be the phone just talking to the tower, right?
God,
Yes.
what you did to the sound.
And that doesn't mean someone searched the phone. Is that right?
Correct. No one could have searched this particular, if we're talking about 1B7, no one could have searched it because it was locked.
And then finally, I want to ask you about defense exhibit 1. Were you asked to look to see if there was a particular app on 1B7 called Third Eye Intruder?
Yes, I was.
And may I approach to hand her? Sorry, may I have defense exhibit 1?
Okay, guys, I'm going to start taking a quiz.
App on it called Third Eye Intruder.
Yes, it did.
I will
And
not
what
be
is Third Eye
walking that
Intruder?
for about 15 minutes.
This particular app is made by, the vendor was Ashnatech, and it can be used for a couple of different things, but it will take a screenshot of an individual who is attempting a passcode or to unlock a phone, or I can't necessarily say they were trying to unlock the phone, but something touched the pattern on the screen and then took a picture of the individual. If you have configured it to do that. So it can be set up to do that, yes.
And regardless of who may have touched the phone or tried to enter the passcode into the phone, when the phone came to you, the phone was locked.
Correct.
And you were the person who had to unlock it.
Using Celebrite Premium, yes.
And could anyone unlock it other than Celebrite Premium? Well, prior to you, I'm sorry.
Possibly the gray key could have, but I can't say that it would have been successful. I don't know because I didn't attempt that.
Yes.
That's all I have. Thank you.
Good morning.
Good morning.
Agent Hunter, are there other programs besides Celebrite and Gray Key that?
Those are the only two in the FBI's possession in our lab.
But there are others that kind of exist in the world outside of your possession.
Possibly, I'm not familiar with any other products.
Is Gray Key able to extract parts of a phone, or does Gray Key also perform a full system extraction?
Full.
And you mentioned Celebrite Premium. Are there other versions of Celebrite?
Absolutely.
And do those other versions of Celebrite extract less than the full file extraction?
Yes.
And I want to talk about the difference between that. So a full file extraction will include data that has been deleted from the phone, right?
Correct.
And in this case, some of the data that was extracted in this full file extraction didn't have a date associated with it.
Okay.
Okay, you didn't review the phone?
No, ma'am.
Okay, well then I won't ask you about that. Is the same true for Gray Key? If you do a full file extraction, it will also pick up hidden files?
Absolutely.
Okay, and that includes deleted files?
Correct.
Okay. Let's see. I don't have any other questions, thank you.
Okay.
Why did you have to use the premium and not just regular Celebrite?
Well, it was locked, so I couldn't use the regular Celebrite, which that's an advanced logical extraction would have been my only possibility with the regular Celebrite, and I needed it to be unlocked.
Thank you.
Just to clarify though, you did say you're not sure Gray Key may have also been able to unlock.
Yeah, so this gets into a little bit of budget issues, but there's a pricing difference to purchase the Android feature on the Gray Key, and we only have the Gray Key for Apple.
So the reason you had to use Cellbrite Premium was because of government budget concerns?
Correct. We have the premium we use for Androids and the Gray Key that we use for Apples.
Understood, thank you.
Anything else?
Not from the state, sir.
Can she be excused?
Yes, sir.
Yes, sir.
You're excused, Rachel.
Thank you. Okay.
Oh, hell no. I'm done with the quiz. Sort of. Oh, have mercy. Heidi Klum and Janelle Montre wore elaborate ET costumes. Heidi Klum is very well known for her costume.
This was the state's original.
Gosh, that's exquisite costume,
There you
man.
go, you go,
Yes,
there you go.
Spend thousands
Well,
on them.
okay, yes, sir. This evidence that we presented today is in response to the defendant's amended motion to suppress, which was filed after our last hearing. And in that motion to suppress, the defense alleges that they had evidence that would contradict that the phone was not searched or that the phone was searched prior to the warrant. So let me say that the other way around. I apologize. The state's position is, and the evidence has shown, that while 1B7 and 1B8 were seized without a warrant, which we have already covered the last hearing, and I don't wish to cover unless the court wishes me to recover that. Okay, thank you. That those phones were not searched until a search warrant was obtained. And in fact, you've now heard, and you knew from last time, there were 2 search warrants, 3 total, but for each phone, two warrants for the phones. We are here today because the defense filed the amended motion saying that they had evidence that that's not true. And I think the evidence has been really clear in the hearing today that what happened to 1B7 is that Special Agent Karate tried to put it in airplane mode, couldn't. The phone was locked. He couldn't unlock it. He didn't search it. It was left with the GBI. Eventually, it made its way to UGA PD, where Agent Hipkiss picked it up, not in airplane mode and in a Faraday bag. And then it had to be physically broken into by Cellubrite Premium. There's no way it is even possible, and the evidence is uncontroverted at this point, that agents, law enforcement officers, or anyone could search that phone prior to Judge Stevens signing that warrant on February 27th. It's clear from even the own Cellubrite reports that the defense made and put into evidence. Candace Hunter at the FBI was the only person who could open that phone, and she did so only after receiving that warrant from Judge Stevens in the manner in which has been described to you. I hear this complaint coming that they exceeded the scope of the warrant. Well, let me tell you who exceeded the scope of the warrant. The defense did. The first time Special Agent Hipkiss even saw data that predated what Judge Stevens offered him, allowed him to take, is when the defense created those exhibits and gave it to him.
We're going there.
He testified to this court, and you will, I'm sure, in camera review his seizure report.
Oh my gosh.
And his seizure report was set at the parameters in which Judge Stevens authorized him to search, and he was permitted to look at items which had no date on it to determine whether in fact they fell within the scope of the warrant. And if they did not fall within the scope of the warrant, he didn't tag them. If they did fall within the scope of the warrant, he tagged them, and tagging them really is just their way of saying he seized them. And they are in those reports that have been admitted to you as State's Exhibit 31. From the plain language of Judge Stevens' warrant, he allowed the FBI to download the entire phone. Not only does it make logical sense that that's the only way they could do it. So it would be like saying, I guess the defense is trying to tell this court, and I'd like to see some legal authority on it, that you can search the phone, but we're just not going to allow you to download it. Well, then you're back to what Special Agent Hipkiss said. Well, we're just going to have to physically go through the phone. And if you do that, then you're absolutely looking at everything in the phone. There is a tapestry of cases out there, and I'm happy to provide them to the court about this theory. And it's not a new theory. And I would say that defense's argument is rather novel. There's definitely no evidence that somebody got into that phone before it was cracked. So there's just no evidence to support that allegation. But what they're trying to tell this court is that, well, you're going to have to search the phone without unlocking it. There are cases out there when it comes to computer searches. And in Riley v. California, when we first started this cell phone journey a long time ago with the United States Supreme Court, they likened, and Judge Roberts likened cell phones to microcomputers. And when searching computers, and I think all the case law associated with the search of computers is very helpful here. And I guess my argument is two things. One, they didn't exceed the scope. Judge Stevens authorized exactly what happened here, and they processed the warrant in the way that he authorized it. And number two, if they think that the scope succeeded, we're not using anything that's not in Special Agent Hipkiss's reports, so it's moot, and there's no harm. And three, and finally, they're asking you to establish some kind of procedure where you're allowed to search a file cabinet for the tax returns from 2020, but you can't look at all of the other items in the file to see if they are in fact the tax return from 2020. I mean, if you want to just relate it to other objects or relate it to computers. And so for computers, and I have a few cases to cite for the court, and I can provide them in writing as well if the court wants a brief on it. But quite frankly, United States versus Kahani, Khani, at 502 Fed 3rd at 1281, you can endorse, and this is an 11th Circuit case from 2007, endorses a search of a computer where they eliminate files that are unlikely to contain material within the scope of the warrant. So basically, what the federal courts have acknowledged, and what the Georgia Supreme Court also has acknowledged, is that clearly you have to look at everything within the files to see if it's within the scope of the warrant or not. And if the court would like further briefing on this, and I'm curious to see defense's case law on this, because none of it was in their amended motion, I'll be happy to brief it at a later date if the court wants further briefing.
Ms. Beck?
Yes, Your Honor. So first of all, in our motion to reopen the evidence, we did not allege that we could prove the phone was searched. What we said was, at the last hearing, the state alleged the only reason the phones were seized without a warrant was to keep them safe and prevent any sort of tampering. And that's what the evidence today has disproven. The phones were not kept safe, number one. They were tampered with, number two. Agent Karate said that he tried to access the phone. He was caught in the act by the third eye intruder. It may be that he was only trying to put it in airplane mode, but the point of the matter is, without a warrant, they tried to enter Mr. Ibarra's phone. That is exactly what our case law prohibits them doing. All of this could have been prevented if they had just, before they seized the phones, gone back to the courts and gotten a warrant to seize them, to put them in airplane mode, to search them. All of this would have been circumvented. The same goes for the software that they use to download the phones. You know, I sympathize with the agent's contention that there is no way to limit Cellbrite Premium. But number one, Cellbrite Premium is not the only software they could have used. They chose to use it because of budgetary concerns. And number two, all of that would not be an issue if they had been clear with the judge who signed the warrant that that's how it was going to happen. If they had said, Judge, you know, we cannot limit the data we extract. It's going to be everything. And then we will set up a reviewing team to screen out the data that was unauthorized. And then we'll have other agents review the data that was authorized. We wouldn't have an argument. But they didn't do that. There is nothing in their affidavit to the judge that suggests, Judge, despite the time limit you impose in your search warrant, we are going to get everything. And they didn't do the system that is generally recognized by case law, where you have some agents review the phone and separate out the data that was lawfully seized and lawfully seized. And then you decide, the agent's working the case, what you're going to seize. The same agent did both. Agent Hipkiss filtered the data himself, and then Agent Hipkiss decided what was within the parameters of the search warrant to seize it. The last thing I will point out, Your Honor, is that the state and the agents are trying to make this distinction between authority to search and authority to seize. And I don't think that that is in line with the warrant. The warrant is, you may search data within January 1st of 2022 to the present, and you may seize data within that time range. There is no, you can search everything, but only seize the data within that time frame. So their distinction is a distinction without a difference, because a search warrant is talking both about the search, which is the extraction of the data from the phone, which was everything, and the seizure. And this last thing on that point, Your Honor, is that the state is saying we only seize data within the time frame. That's not true. Agent Hipkiss said that there are images in his report that don't have a date at all. There is no way for the state to verify if those images without a date associated with them happened, were deleted from the phone within the date range authorized by the warrant or external to it, because there's no data. So we can't trust with confidence the state is only using evidence within the authority of the warrant. And then the last point on this, Your Honor, is that that is all about how the search warrant was executed. But our original argument, which we stand on, based on State versus Wilson, 315 Georgia 613, is that the search warrants were overbroad because it authorized what the government contends. It authorized a full system extraction for deleted data that could not be contained by any date range for 10 devices without identifying which device belonged to which defendant. That is the definition of an overbroad warrant. There is no limitation as to the data the state could have seized based on their interpretation of the warrant they got. And so for that reason, Your Honor, we ask that Your Honor grant our motion to suppress, or at the very least, limit the data that the state can use at trial to the data time range authorized by the warrant.
Snap.
You want to be heard any further?
Well, a little persnickety, but
Not inviting you to read.
no, but just the phrasing of defense counsel, well, maybe he tried to put it in airplane mode. If defense counsel has evidence.
Wow, these women are going at it, y'all.
Testimony of it, now's the time, because what the evidence is that he did try to put it in airplane mode.
Thank you. We'll go to the next matter.
And Judge, is that the 702 on the true allele, or do you want to take up the fingerprint argument?
I'm
I'm
gonna
looking
believe that.
at her
I'm-
photo.
I'm thinking.
Beautiful
the,
girl.
The DNA dollar motion would be next.
Okay.
Because I imagine there's.
We're gonna follow
people that are involved
this
in
one.
that we just need to move on, so. that's-
And Judge, I don't have any idea what the state's presentation is on that. I would ask to be heard on the motion to continue,
Okay.
obviously prior to this going on. And so I can
Fine.
take that up now.
Now is appropriate.
Okay. Judge,
Yeah, this is
I would,
one we're going to follow.
we're here on the motion to continue filed.
Adding to
On
Discord.
October 25th, by the defense as to the 702 motion on the true allele. We had, as the court is aware, we had filed a motion to continue that had been granted by the court prior to the October 11th scheduling for that 702 hearing for the true allele. The reason for that is that we didn't have any of the underlying data, which could be analyzed, evaluated, or otherwise looked at, even by an expert had we had one. And so the state agreed to that continuance, the court granted, and we are in the same position that we were before. We were granted, we were given access to the underlying true allele data and underlying DNA data at 5:30 on October 10th. And having spoken with an expert in this case, we would not be prepared to have anyone look at that or be done looking at that, and to be able to assist us in our evaluation and challenge of that evidence for at least 6 weeks. Now, that is not our doing. That is not the defense's doing. That is not Mrs. Ross or Ms. Ross's doing. I believe that is perhaps just a circumstance of this case.
Yep, we're covering this one.
But it is
Definitely.
necessary for us to be able to proceed with this motion, to be able to consult someone who's an expert in this field. The amount of information, number one, is voluminous. And in terms of the ability to sift through that data in the time frame that we have been given, which is, let's call it 2 weeks, 2.5 weeks.
Hi,
is
Lisa.
unreasonable.
Welcome.
The complexity of
Welcome.
that data
Ronnie,
is beyond the scope of certainly
don't
my
forget,
ability
you need to send me your
understand
address
without
in
the assistance
Discord.
of an expert. And as far as I know, the assistance of anyone on the defense team in terms of our training in math, in probability, statistics, as well as computer science, that will be what I believe will be presented by the state in this case. There is also a novel aspect.
I've never
of
heard this
Shirley
one.
that is
But
pertinent.
we'll be following
to
it.
The court's decision to grant a continuance in this case. As far as I can tell, there are 3 cases in Georgia from the appellate courts that have addressed true alio at all. The only one that does that in any substance is Gates versus the state. That's 308 Georgia 238, a case from 2020. I don't have these cases printed out. I'm sure that Ms. Ross is abundantly aware of them and familiar with them. Having done a case that took them a year to just prepare for one challenge to this test. But Gates, as well as Smith versus the state, 315 Georgia 287, a 2022 case, involved extraordinary motions for new trial where the defense was introducing true alio, and that was not challenged by the state. The state had not objected to the introduction of the evidence, and the argument in those cases was whether or not that true alio evidence, not the scientific basis for it, but whether or not it constituted new evidence for purposes
wow.
of the extraordinary motion for new trial.
Didn't know that.
statute.
Interesting.
The appellate courts in Georgia have not ruled on the admissibility of this science or math or computer program that the state is using to analyze underlying DNA evidence. And the only other case is Nunger versus the state, which is 316
What's wrong, baby
Georgia,
girl? Did that kid take
one,
your
the
phone?
2023 case.
Okay.
And that ruling came down to an issue as to whether or not the defense had preserved an objection about true alio that was decided under the Harper standard. And so I don't think that it is particularly applicable to the admissibility of true alio under Dauber. And the fact is that those first 2 cases that I mentioned really highlight the novelty of this science, as the appellate courts have outlined it, which is that they were ruling that it was new evidence. It was a new type of evidence that was not able to even be used by the defense, and such that it allowed them to proceed on an extraordinary motion for new trial. And without the ability to hire an expert and to have an expert evaluate this case, there is no way for us to effectively cross-examine any of the witnesses in this case. I've looked at it. I have tried to understand what that data is, and I am unable to do so. So, Judge, as to cases that are out there right now, and I believe that Ms. Ross would be familiar with the Deeds case, I think it was Dodge County. That case required a year's worth of preparation with expert witnesses. and a week's worth of litigation just about the science of this. And that, the amount of time that we have is obviously nowhere close to that. So I would like to just offer a proffer for the court as to the timeline of when the defense began asking for this evidence. In mid-August, the defense mentioned this to Ashley Hinkle, who was the GBI agent who handled the cases. She told us that we needed to go through their open records department. On August 19th, the defense made a request through the open records department to get the underlying DNA and true allele data. That request was denied by the GBI because the testing was not completed in the case. So that would have put us in late August for this. The GBI informed us that they expected the testing to be done by September 2nd and 16th. Ms. Ross helped us in trying to get this open records request done. We offered to limit the open records request to 3 or 4 tests that were done in an effort to speed that process up. We were assured that we would get that information around late September, September 23rd. The GBI says that they would see what they can do about expediting that process. And we didn't get anything back until October 10th. I can wait for the introduction of the test, but I don't think that this will be in dispute, and I will offer it as a proffer to the court. I think Ms. Ross would be able to comment on it. The tests that were done that were specifically limited in the open records request, all of those tests had been completed by I just look here, Judge, June. I believe the latest test that I have here would be a true allele report that we're given them item number 56, and that would have been done on June 10th of 2024. And so, Judge, the fact that we were not given this information until 12 hours, 15 hours before we were scheduled for a motion, again, I don't believe is Ms. Ross's fault, but it doesn't allow us to effectively evaluate or confront the evidence that will be presented to the court today. We're making a request for continuance and would object to going forward based on Sixth Amendment right to counsel, to effective representation of counsel, Fifth Amendment confrontation.
That's my sign to turn on the air conditioner.
Okay. Fifth Amendment right to confrontation, due process considerations, and any corresponding pieces of the Georgia Constitution. This is not made for delay. This is not made for.
I really
purposes of
appreciate
delay. We would
Ruby
like to
Cheryl.
be going through
Really
this,
do.
and I can tell the
We do
court in my
pineapple,
place
no
that we have
politics.
made every effort to consult with and talk to lawyers who are more familiar with this information than we are. And at each step of the way, they have
Dr.
told us
Bullbutter,
that this cannot be
we
done,
don't
that
do
it is not
what is
reasonable for
pickles.
this to
We
be
do
done,
pineapples.
that we need to hire an expert.
I love pineapple.
And we need to have an expert
Oh,
evaluate
Lord.
this information. And there are reasons for that.
Yep.
There are reasons for that, even from a cursory review of someone who is more familiar with this type of information than certainly any of defense counsel is. I would just ask the court, and what I would present to the court is that's my approach.
Yes.
We love you, Miss Groovy Cheryl.
Versus the state, which is 255.
You're all good.
434. I presented this to the court because I think that it is helpful in deciding the issue as to whether or not there is a right of a defendant to have the assistance in evaluating and
Hello, Zach.
understanding evidence, especially evidence that is novel. This is a 1986 case, and it is about dental records. It is about the use of dental impressions.
Zach.
And whether or not the defendant has the right to have an expert evaluate dental records. At the time, that was a novel approach to forensic science, and the court said that where a defendant has made a timely request, and pre-trial, I believe, would be a timely request for that expert on a novel type piece of evidence that is critical to what the state is going to present. They're entitled to an expert.
Yes, we do.
McWilliams versus Dunn is a Supreme Court case, and that is.
I hope y'all can't hear my dog snoring. I feel it on my eardrum. She's way over there.
137 Supreme Court, 17.
Thank you, Zach. I don't know what just happened. Something just went down. I'm working on homework. We had a live at 12. I may have to delay. That was a wonderful stream. It's all good. But this is this.
2012, so about 12 years.
Something happened. There we go.
Jennifer Bracamonte.
No, we don't have anything going on that court.
Well, good. Come on up. I thought you were correcting the way I said something last week. She was in there.
I'll be right back, y'all.
You will give today in the matter of the state of Georgia versus Jose Ibarra will be the truth, the whole truth, and nothing but the truth. I do. Please take a seat. Spell your first and last name.
Jennifer Bracamontes, Jennnifer, last name Bracamontes.
Where are you employed?
I am employed at a company called Cyber Genetics, which is located in Pittsburgh, Pennsylvania.
What is cyber genetics?
Cyber Genetics is a technology company that develops and uses the Trulio casework software that's used to interpret DNA data.
How long have you worked for cyber genetics?
I've worked for Cyber Genetics full-time since 2012, so about 12 years now, and I was an intern for a year before that.
Tell the court a little bit about your education and your background.
I have my Bachelor of Science degree in biology from Duquesne University, which is located in Pittsburgh. I also have my Master of Science degree in forensic science, also from Duquesne University.
Have you, tell us a little bit about your day-to-day duties at Cyber Genetics?
So at Cybergenetics, I'm the casework manager, and that just means I'm responsible for overseeing part of our DNA data processes. So with Cybergenetics, we have two parts. We have a service part where agencies will send us data to run the TrueLeo software on, and then we also have we sell our software to other laboratories like the Georgia Bureau of Investigation Laboratory and others in the United States. So I'm responsible for just part of our internal casework process, analyzing that data, writing reports, and then testifying in court about TrueLeo results.
Have you analyzed TrueLeo data before?
Yes, I've analyzed DNA data using TrueLeo in about 1,000 cases.
Have you testified to your results before in court?
I have.
Approximately how many times?
57 times.
Have you been declared or qualified as an expert in the field of DNA evidence interpretation before?
Yes, I have.
Approximately how many times?
In the 57 times I've testified.
And can you tell us a little bit about the number of cases that you have worked in the TrueLeo software?
Sure. I've analyzed about data from 1,000 cases and then probably close to 3,000 different evidence items.
And Your Honor, this time I'm going to, may I approach the witness?
Yes.
I'm handing you what's been marked for identification as State's Exhibits 32, and then 33 and 34. I'm just going to leave them up here so I don't have to walk back by. Do you recognize 32?
Yes.
What is it?
It's my curriculum vitae.
Your Honor, at this time, the state would move to admit State's 32.
No objection, Judge. 32 submitted.
And at this time, also, the state would tender Ms. Bracamontes as an expert in the field of DNA evidence interpretation.
Any objection?
Judge, I don't have a way of evaluating that. It certainly seems that she's more qualified than I am.
Bye-bye.
I will take that.
I look like I have horns.
Before it was announced.
Or am I getting thick around here?
Witness testifies as an expert in DNA evidence interpretation.
I would like, if you could, to explain to the court TrueLeo and how it works and whether it's reliable and reproducible. So to do that, you have prepared 2 PowerPoints for today, and you remember that?
Yes.
Okay, and are they in front of
Right
you as
here,
State's Exhibits 34
one-sided all of a sudden.
3?
Yes, they are.
Could you first start with State's 33? What is it?
It's a PowerPoint that explains the overview of the TrueLeo process, some of the background, how it works, and how the results are presented.
And the state would move to admit State's 33.
Any objection to 33?
It's the first one.
I'll leave it to in the discretion of the court. I think that this would just be demonstrative in terms of what Ms. Bracamontes' testimony would be. I don't think that we need to admit this into evidence.
She's asking for it to be, I'll admit it. I mean, I'm the only one that's going to be seeing it at this point. So it's not in the trial.
I understand.
And
That's
state,
a better way for it to be part of the record, in my view.
yes, sir. And that's why I'm moving to admit it.
And I will. 33. And is it 34 another PowerPoint?
Yes, sir. State's 34, what is it?
It's a PowerPoint that goes through TrueLeo's validation.
And did you prepare that PowerPoint in preparation for your testimony today?
Yes.
State would move to admit State's Exhibit 34.
Same thing, Judge.
I understand. The objection is noted as far as admitting the evidence. I will consider that and admit 33 and 34.
If we could, Judge, they are admitted for the record. I think an easier way to display them so that defense counsel.
My hearing aids are not connecting, so give me a second.
Just through the overview, there are no case specific.
I don't want to go to the other
references
buds.
PowerPoint, so I would just request to play it that way. It'll just be easier.
No objection, Judge.
That'll be fine.
So let's start then, and may I approach the witness and give her
Yes.
if you could, hand it to a pointer for the record, we're starting first at page 33 at page 1. It's just a cover sheet,
Yes.
right? Okay, so let's go in. Tell us what is true allele.
So starting off with some of the basics, starting with DNA biology, the human body has trillions of cells, most of which have a nucleus that has all of our DNA that's wound as chromosomes. And there are specific regions on those chromosomes or locations that are useful for identifying people.
And go ahead. So does true allele start with traditional DNA analysis?
It starts with the data produced by that traditional DNA analysis.
Okay, go ahead.
And so those regions that are useful for identification are called short tandem repeats. And all they are segments of our DNA where there's some repeated DNA fragment, some number of times in a row. And the number of times that segment's repeated corresponds to an allele number, which is inherited from our parents. And labs count up that number of repeats and use that number to identify people. Because it's not only 10, it could be there's 10 to 20 different possibilities at any one location for that allele number.
Okay, go ahead.
And so we get one allele from our mom and one from our dad. And so at every DNA location, there's a pair of alleles. So here in the example, maybe a 10-12. And that would be what's called the genotype at one DNA location. And so it's not only 10 and 12 in every person. These regions are variable. So somebody could be 13, 14, somebody could be 15, 16. There's about 10 to 20 different allele possibilities, which results in about 100 possible pairings of those alleles. And then that's just at
I'll be
one
back,
location.
y'all. I got to
So
get other
testing
ears.
20 or so different locations makes a person's overall genotype relatively unique.
And how does true allele use the data from a genotype? So tell us about it.
So with simple DNA, like DNA from one person, the lab takes that sample, they extract the DNA, make many copies, and produce the data that we see in the middle. And when it's from one person, you'd expect to see no more than 2 allele peaks. And so looking at that data, a person or a computer can then say, well, the genotype at this location would be a 10-12, because that's what the data is showing us. There's nothing at 9 or 11 or 13. And so then with simple DNA, you can just compare that with a known reference and calculate a match statistic.
What is a known reference? What are you talking about?
A known reference would be like a swab from a known person, so like a cheek swab or something that we know came from that person.
Okay. And so that's simple DNA. What about a mixture?
So with DNA mixtures, which are just samples that have more than one person's DNA, let's say in this example, maybe there's 2
Groovy.
people. The lab does that same process to produce that evidence data that you see in the middle.
We
But now there's more than 2
a
people,
Discord.
which indicates a mixture. So now it's a little bit trickier to say, all right, which of these alleles pair together for each of the people? So let's say, but the data still guides that interpretation. So 10, 11, and 12 are the possibilities for the alleles at this location, because that's what the data is showing. So let's say we know one person's a 10.
We have a lot of information and stuff there. Connect with me on Discord and we'll get you hooked up.
Looking at this data,
We don't have
that
anything,
second person
but we're getting it.
is an 11 because that's not explained by the 10 or the 12. So pairing that 11 with 10, 10, 11 with itself, because you can get the same number from both mom and dad, or with 11, 12, that list of allele pairs is then given some probability or how well they explain the
in
data.
my
And that's the evidence.
humble
that list of allele
opinion.
pairs and their
I say it
probability.
all the
And then that in the same way can be compared
I
with
may
known,
joke. I'm a
person's
hope,
DNA.
in my
And it
humble
would just
opinion.
reduce what that match statistic would be in the end.
I have several of them. It
And
should be
does the
changed.
computer do
How
the
about that one?
analysis in true allele?
Yes.
So
I
tell
have
us
that
about
one.
So what True
I really
is
like
a
that one.
computer technology
I
that
say, in my
uses
humble
all of the
opinion,
DNA data
all
to work
the
out
time.
the different
Hello, toxic.
computers that are there. So in this picture, this is what DNA data actually looks like at one location. Along the bottom is just the size of that DNA fragment, which then allows the scientists to know what those allele numbers are on top of each of those peaks.
What do you
And then
do in life?
along the left, the height of each of those peaks corresponds with the amount of that person's DNA that's there. The taller the peak, the more of that allele that's there, smaller peaks, there's less DNA. And there's an overall pattern, highs and lows, and variation. And the computer uses all of that information to work to separate out the different genotypes based
What's
on
going
the
on
data.
with my hearing aids?
And was this at one point done by people before true allele?
Yes.
Okay, so tell us about the difference and go to the next slide.
So with prior to computers, what people did to simplify the problem, they basically drew a line through the data, and anything above that line they'd consider, anything below was discarded. So, and what's been seen in studies since then, and why people are moving to computers, is you lose a lot of DNA information by using those thresholds. So in this example, the 17 and 18.
We're going to pause this. I'm going to read this to catch all of us up. I want to lower me just a hair. Okay, here's what I know quickly. Okay. Jose Ibarra is the man accused of killing nursing student Laken Riley on the University of Georgia's campus. Will be back in court Friday. Okay. Ibarra is charged with murder and other crimes in the February unaliving of Riley. A 10-count indictment accuses Ibarra of hitting a 22-year-old Augusta University College of Nursing student in the head, asphyxiating her and pulling her up her clothing with the intent of wrongfully intimate assault on her. Ibarra pled not guilty to the charges. Prosecutors previously announced evidence against Ibarra, including thumbprint from Riley's phone, DNA of her fingernails, and video footage. Ibarra's defense has argued that the DNA evidence is unreliable, filed a motion in October, tried to remove the information collected from the cheek swab from evidence, argued that it was collected by law enforcement without warrant. The DNA evidence was supposed to be discussed during a previous hearing, but lab results were not ready by that day. Ibarra wants the cell phone evidence thrown out. Riley's body was found near Lake Herrick in February after she didn't return home from a morning run. Investigators say that they were able to identify Ibarra as a potential suspect when they searched his brother's apartment where he lives. During the search, 2 of Jose Ibarra's cell phones were seized, but were not searched until later warrant was obtained. Ibarra was arrested that day on an outstanding warrant before being charged with Riley's murder. As with the DNA, Ibarra's attorneys want to suppress those cell phones, the cell phone from being introduced as evidence. In a motion granted by Athens Clarke County, the Superior Court Judge H. Patrick Haggard on October 28, the defense can seek to reopen evidence related to previous motion to suppress heard earlier in the month. The document did not reveal what evidence might lead to both of the cell phones being included. In October, Superior Court Judge Haggard denied a request by the defense to move the trial outside of Athens, Clarke County. The defense cited the extensive media coverage would make it difficult for Ibarra to receive a fair trial, and that the jury pool might be inherently biased. So that is where we are. Okay, we're going to need to get more. All right, my research mods. I know Ronnie's not on with us. Oh, there you are. Hi, Ronnie. When you have an opportunity, can you get the research mods on this one, please? I would appreciate it. Okay, let's continue.
Have been considered by doing a manual analysis. And so that information would be lost.
Okay, and tell us how the computer does it. And also let us know what is the role of a human scientist in true allele?
Sure. So with TrueAllele, it's taking all of that underlying data that a person would upload to it. And then based on their expertise, the analyst reviews that data at every single DNA location to get an estimate of the number of contributors that are indicated by the data. And so they input that number of contributors. In this example, let's say there's maybe 2 people's DNA. And then what TrueAllele does is it works to propose different combinations of allele pairs and assess them against the data and say, well, which ones explain the data better than others? So in this example, maybe I asked TrueAllele to solve for 2 people. It may say that one person's allele pair proposed that is a 1718, indicated by the blue boxes. And maybe a second person is a 1519, represented by those orange boxes. And then by comparing those colored boxes, that pattern, to that underlying data, TrueAllele looks at it and says, the tops of those boxes match up with the tops of the peaks. This is a good explanation of that data. So those resulting combinations, the 1519 and the 1718, would get higher probabilities for each of those respective 2 contributors. And the computer is not just trying out this one possibility. It's trying out, thousands of different possibilities, moving the boxes around, changing the heights, and just comparing it all to the data to say which ones explain the data better than others. And then it's not just trying good ones, it's also trying ones that don't look like the data. And that combination will get lower probability in the end.
And after it tries all the combinations, then what?
The result is a genotype, which is just a list of allele pairs on the bottom with their resulting probabilities. And it does this for each of those 2 contributors at every location tested. And this is at that one location we've just been looking at for that blue contributor, that more minor contributor, which was the 1718. And TrueAllele is doing this just looking at that evidence data, never seeing a comparison reference at this point. And here, with this simpler problem in this example, that 1718 was given a lot more probability than the other option it tried out.
And at what point does the reference sample of potential contributors, for lack of a better term, and contributors are just people, right?
Yes.
Okay. So at what point does a reference sample of a person of interest come into play in TrueAllele?
After the evidence genotype, that blue bar has been inferred. So it's only after TrueAllele seen that evidence data is a reference ever introduced.
And how many times does a human ask TrueAllele to infer genotypes in one sample? How many times is it ran?
It's run at least twice to show that there's reproducible results between samples.
Is that also concordant? Is that a word you use sometimes?
Yes. So just referring to concordance, meaning you get a similar result each time the computer's run.
And then what does it give some type of match statistic?
Yes.
After the process is run. And you say we just looked at one allele pair here. How many pairs does it look at, the computer?
So it's trying out virtually every possible pairing for those different contributors and then comparing them against the data at each location for both of those contributors.
All right, go ahead. But how many locations are there? That was my question, sorry.
Oh, it depends on the kit that's used. I believe if it's the Global Father kit, it would be 21 different locations.
Okay, go ahead.
And so after those evidence genotypes are inferred, you can compare with a person relative to the chance of a coincidence. So if you take somebody random out of the population, what's the chance they have that allele pair? And so all the match statistic is just comparing the probability that somebody contributed their DNA or an evidence match versus the chance that it's somebody else or just somebody out of the population. When you have a higher probability of a match versus that coincidence, which is the brown bar in this picture, that gives you an inclusionary statistic. And if it's the other way, where the brown bar is higher than that chance of a match, it's an exclusionary statistic. So TrueAllele can compare with anybody.
So TrueAllele can both include or exclude depending on the data.
Yes.
Go ahead.
And then let's say in this example, maybe the person happened to be a 1718. Well, that would give an inclusionary match statistic at this one location of 8 times more probable than a coincidence, because it's just comparing that 93% versus that 12% chance of a coincidence. And then that same process is done across, in this example, it was 15 locations. But it just depends on the DNA testing kit that's used, how many locations it would do this for. Trying out those patterns, comparing them with the data, writing down those evidence genotypes, and comparing against the reference to calculate the match statistic, which is just how far each of those blue bars sticks out. And then by multiplying these numbers together, that comes up with the overall match statistic.
And is that called a likelihood ratio?
It is.
Can you explain that to us and how it looks in a report?
Sure. So the way the match statistic is written is just a match between the evidence item and the person we're looking at is 11.8 billion times more probable than a coincidence. And all that is doing is just assessing what's the chance that they contributed their DNA versus the chance that it was somebody else. So it's just comparing that ratio of those two probabilities. When that top number is higher or larger than that smaller number, you get an inclusionary statistic. And if it were smaller in the numerator than that denominator, you get an exclusionary statistic.
Thank you as the gavel
And
drops.
How broad of a range can the inclusionary statistics go?
It could range basically, so if 1 would be your middle point, which is no information because they'd be equal, it would go from there all the way out to, it could be 30 zeros after the 1. It could be larger than that, depending on that reference profile and how rare it is in the population.
And what about the likelihood ratio statistic? If it's higher, does it also mean that the person may have contributed more of their DNA?
Yes. As seen in some of the studies, which we'll talk about, the amount of DNA a person contributed, it can be predicted based, the match statistic can be predicted based on that. So it correlates with that. More DNA from a person, you expect a bigger number. If there's less DNA, you'd expect a smaller number.
And Trulio is only used to interpret mixtures, is that right?
It can be used, it's primarily used for mixtures, but you could put a single source sample in and it'll just say, yes, these are the same, essentially.
All right. So tell us how the likelihood ratio relates to the log.
So when you have the likelihood ratio, that number, that bigger number, a different way to represent it would just be the logarithm or the number of zeros that follow the 1. So when you have a number, of 11.8 billion or so, it would be a 1 followed by 10 zeros. And so it's easier to visualize in some of the studies, which we'll see in the logarithm form, or the number of zeros after the 1, versus looking at, billions, trillions, millions, or so.
And is the likelihood ratio just some kind of hypothetical construct, or does it actually mean that person's DNA is present in the sample?
It measures the chance that they contributed their DNA versus the chance that it was somebody else. So it's just weighing those two different possibilities.
But does it mean their DNA is present?
It means that there's statistical, association between the evidence and that person.
Go ahead. And then is there an error rate associated with Trulio?
Yes. So there's both an overall and a match statistic specific error rate. And with Trulio, we can basically calculate all trillion possible people. And in this image, the bottom just shows that logarithm form, or the number of zeros after the 1, with 0 being no information, 10 being, 10 billion, and minus 10 being 1 divided by 10 billion. And when we compare virtually everybody that could exist DNA to this specific sample, they're largely excluded. And there's a very small chance of a false inclusion. There's nothing to the right of 0 there. And then when we can calculate an error rate based on that for any match statistic as well.
Sorry.
And is what is the math, based on in the computer?
The math, it's a statistical model, so it's based on Bayesian.
Dr. Goldbutter, go into their live and request it.
Statistical sampling. So just.
Can you speak a little into the microphone? Because it is kind of, your voice travels a little bit.
There you go.
It's hard to hear you.
Sure. Is that better?
Yes.
Okay. It uses, it's a statistical model that uses Bayesian probability modeling and Markov chain Monte Carlo statistical sampling to work out those different probabilities and proposing and assessing those different possibilities.
And are either one of those two statistical modeling things that you just mentioned particularly new?
No.
Tell us why.
The Bayesian modeling has been around since the 1700s, and then as a mathematical concept. And then the Markov chain Monte Carlo has been used since about the 1950s with the Enigma, or I guess during World War II in the Enigma project.
Now, how long has TrueAllele been around?
TrueAllele was first developed in 1999 and then went through about 10 years of innovation and testing, and then was first used in casework in 2009.
And before being used in casework, you mean like forensic casework, like what courts and such like that?
Yes, the first TrueAllele case was in March of 2009.
And we're going to get to it in the next PowerPoint, but before I dig into States Exhibit 34, has TrueAllele been validated?
Yes, it has.
And what is validation?
Validation is just testing any method on data. So putting data in and reviewing the results, and it's used to see that the system's working as it's proposed to and establish any error rates.
And since TrueAllele has been used in forensic work, casework since 2009, how many TrueAllele reports total from not only your lab, but across the country, you think have been produced?
Oh, in the thousands or tens of thousands.
How many laboratories are using TrueAllele?
There are currently 10 crime laboratories that use TrueAllele in their everyday casework process.
Has TrueAllele been used in non-forensic settings as well?
Yes, it has.
Tell us about that.
So TrueAllele has been used to identify victims of mass disaster. It was used in 2006 to reanalyze victim remains from the World Trade Center project and compare with family members or personal effects. And has also been used, it was in a 2009, I think, a bus crash in South Africa as well. And TrueAllele's, also been used to help create some of the DNA standards over time that labs use to test that their machines, like to produce the data, are working as expected.
Has TrueAllele also been used in exonerations?
Yes, it has.
And exonerations in criminal cases specifically?
Yes.
Okay. I want to move to States Exhibit 34. And it looks like you've talked a little bit about the first slide, which is number 2 for the record on the top right corner. But this is explaining DNA mixtures. Can you tell us a little bit about that?
Sure. So the first paper that talks about the TrueAllele results, how it does the statistical model, was published in the Journal of Forensic Sciences in 2001 in a paper called Linear Mixture Analysis, a mathematical approach to resolving mixed DNA samples. And this paper focused on looking at p-kite data and showing that it was that sum of genotypes. So when you compare those colored boxes, how that relates to the data. So the underlying basically model behind it was first published in 2001.
And is that a peer-reviewed journal?
It is.
And what does peer review mean in your world? And what is the significance of a peer-reviewed journal?
Sure. So peer review is a process in science where scientists will write up whatever study they're doing, their test of their system on data. They submit it to a journal, which is just a collection of scientific works. And that journal editor will then send it to at least 2 independent anonymous reviewers in the similar scientific field who will then assess the work for its merit and deem if it's suitable for publication or not. And then they'll recommend either the journal publish it, request some edits, or not publish it.
And how many peer-reviewed journals has TrueAllele been in?
Well, there's at least 8 peer-reviewed validation studies, and then there are some other articles like about the methods that have been published in some other journals as well.
The next slide about that publication.
This is just again showing what we already saw, that the computer uses all of the data and the variation.
Okay. And I want to go ahead and do slide 5.
Mm-hmm. So with TrueAllele, there have been over 40 validation studies done. 8 of those have been published in peer-reviewed journals. The system's objective, meaning it only gets that information from the evidence data, doesn't know, you can't be influenced by human bias at all during its inference process. It's been reported in 46 states and used by 10 laboratories. And then all of the math, the software, invitations to test the system are disclosed in a large Dropbox. And then TrueAllele can statistically include or exclude people. It's neutral. It doesn't, try to just find somebody or
Better.
implicate them in the DNA.
And are these all the peer reviews validation studies that you have already spoken about?
Yes, and the top 5 in the lighter blue are done on laboratory generated data, meaning data that the scientists knew what they put in to establish, the error rates and see how it works when we know what's supposed to be there. And then the bottom 3 are done on casework data to kind of assess how does TrueAllele work on that data in the wild.
And then next slide. Is that Dr. Perlin? Who is Dr. Perlin, by the way?
Dr. Perlin is the chief scientist and chief executive officer at Cybergenetics. He was the one that invented the TrueAllele software.
Go ahead.
And so the first published TrueAllele validation study was published in 2009 in a journal called PLOS-1, and it was titled An Information Gap in DNA Evidence Interpretation. And this was the very first study that was done on TrueAllele. And kind of one of the main points that TrueAllele showed is that the match statistic is predictable. So along the bottom of this image is just the amount of DNA a person contributed. And then along the left is that match statistic, so what that likelihood ratio is. And what we observed is that the match statistic corresponds with the amount of DNA. When you have more DNA from a person farther to the right, you get bigger numbers. And when there's less DNA on the left, you expect smaller numbers until the point where it basically gets that single source inference. So it says, this is basically, it kind of maxes out at one point.
That was the first one. What about in 2014?
So in 2014, this would be, I think it's the 4th one in the series, but this is the first one that assesses how you can validate systems like TrueAllele and introduces the axes of sensitivity, specificity, and reproducibility. And it was published in conjunction with the Virginia Department of Forensic Sciences Laboratory. And it's just titled, TrueAllele Casework on Virginia DNA Mixture Evidence, Computer and Manual Interpretation in 72 Reported Cases.
And I'm going to ask you about sensitivity and specificity and reproducibility separately, but is there another, are there other probabilistic genotyping softwares out there that compete with TrueAllele or do the similar things that TrueAllele do?
Yes, there's about 10 other softwares that would be considered, they're called probabilistic genotyping. So they just use, the math and the probability modeling to look at DNA data.
And is StarMix one of those probabilistic genotyping softwares?
Yes, it is. And that's capital S, capital T, capital R, lowercase m-I-x.
Thank you. Let's talk about sensitivity. What does that mean? And how does that relate to knowing whether or not TrueAllele is reliable and does what you say it does?
So sensitivity just assesses, the extent to which the method, identifies a correct person. Are we finding those true inclusionary statistics? And in the study in 2014, we looked at 101 reported evidence genotypes and just said, okay, what are those inclusionary match statistics? And what do they look like from TrueAllele?
And what were your results? I'll go back there.
And so,
sorry.
Looking at TrueAllele, on the horizontal axis is just the match statistic in the number of zeros after the 1. And what we saw is that there was a wide range of TrueAllele results ranging from lower match statistics, maybe in the thousands, out to over 20 zeros after the 1. The average was about a 1 followed by 11 zeros, or 113 billion. And in this case, we had mixture weights, or the amount of DNA people contributed, ranging from, lower amounts, like say 10% to over 90%. And so just based on, the predictability, we'd expect a wide range of statistics.
And did you do a comparison with human review of the same data?
Yes. And so the original studies more focused on how do computers improve over human review. And in this study, there were 2 different methods done, one with 1 threshold, or the CPI method, where you see there's a smaller cluster of those match statistics with an average around 6 million. And then there was a 2 threshold method, or a modified CPI. and a lot more information was lost with match statistics, in the hundreds. And with TrueAllele, there were those 101 inclusionary match statistics. With CPI, there were about 80, and with the modified CPI, there were only about 50. So using thresholds limited the results that could be reported from that same DNA data.
What about slide 12?
And so we also examined TrueAllele's accuracy in this study. And so when you have a wide range of mixture weights, you'd expect a wide range of match statistics. So that's what the black line in this picture is, what we'd kind of expect.
What is a mixture weight, real quick?
A mixture weight is just the proportion of DNA somebody contributed. So if you have a mixture of two people's DNA, maybe one person contributed 60%, one person contributed 40%, the numbers will always add up to 100%.
Okay, go ahead.
And so comparing TrueAllele's match statistics with what we'd expect, it roughly follows that line and isn't statistically different. But when looking at those human review methods, they differed from, having a wide range that you'd expect when you have a wide distribution of match statistics.
What is specificity?
So specificity allows us to assess the false positive rate. So are we properly excluding people who didn't contribute their DNA? If they're actually non-contributors, are they excluded?
How did you test TrueAllele specificity?
So in this study, there were the 101 evidence genotypes, and we compared with 10,000 randomly generated profiles from the 3 different ethnic populations tested. So there were over 1 million comparisons, and then those were plotted here. Along the bottom is just the match statistics and number of zeros, where you have 0, that's no information. To the right of 0 would be inclusionary, and to the left would be exclusionary. And in this case, most of those statistics where those colored bars are largely exclusionary, with that average information, exclusionary information for those non-contributors, a 1 divided by a 1 followed by 19 zeros. So very, very small, exclusionary statistics. And then we also looked at what's happening past 0, those small inclusionary statistics.
And is that a false positive?
Yes.
Tell us about that. Sorry.
So in the study with TrueAllele, in the over 1 million comparisons per group, we just looked at anything that was slightly inclusionary for those random people we generated. And so with log LRs just greater than 0, so anything slightly inclusionary from, 2 to, in this case, it was out to 1,000, how many false positives were in each group? So there were about between 40 and 50 total across the 3 groups, about 150 total. And then most of those were between 2 and 10. They were less than, a likelihood ratio of 10. So very small inclusionary statistics. And so from that, we were able to calculate the false positive rate overall, which is 1 in 20,000 or 0.005%. And then for match statistics greater than 100, that rate went down to 1 in 1 million because there were very few false positives seen greater than 100 and none seen greater than 10,000.
And how does that compare to humans?
So in this paper, there were actually,
No,
when the lab did their human analysis, they had some false positives that would have been reported in their reports. So with the 1 threshold method, that error rate was about 6%. With 2 thresholds, that modified CPI, that was about 2% for the false positive rate. And with TrueAllele, it was 1 in 1 million or 0.0001% for those match statistics greater than 100.
Is the reproducibility is the last prong of the 3 that we were discussing. And so what about reproducibility?
So with TrueAllele, because it uses a statistical sampling method, you're not going to get the same exact number every time because it's going to propose and assess, make possibly different combinations of those colored boxes. And so, but you'd expect similar results if it arrives at those similar genotype probabilities, those blue bars. And so with TrueAllele, we were able between computer runs to assess, what's that variation? What's that difference between those 2 runs?
Sorry. Okay. And this is when we talk about the 2 runs and the data has to be concordant, right? What is concordant data? And if it's not concordant, what do you do?
So what concordance means is it's just, you know, when you run it one time on that same data, what's your match statistic, which is along the bottom. And then along the left, we plotted what was the match statistic from that second run. So every point, you know, has the likelihood rate or the log LR from one run compared to that second run. And you can see if they were exactly equal, there'd be a 45-degree line they'd all line up on. Well, these roughly follow that, but there's a little bit of variation between them. And so we measured that variation, and it was less than a factor of 10. In this study, it was about a factor of just 2 different between the 2 different runs. And, you know, when they're reproducible, you expect them to be similar every time. And if it wasn't reproducible, you see a number maybe way up in that top left corner.
This is yet another validation study.
Yes, so this was published in the Journal of Forensic Sciences in 2011, validating true allele DNA mixture interpretation. And this study was mainly focused on comparing true allele with human review. So it looked at 8 different case samples and then compared the match statistics on the left between 2 true allele runs, so was true allele reproducible, and then compared it with that human review, that threshold method of CPI. And true allele got about 1 million times more information than human review. And this paper also has a lot of the published mathematics and equations and behind the true allele technology.
And that was in 2011?
Yes.
Slide 20, a 2013 validation?
Yes. So this was published in the Journal of Forensic Sciences in 2013, New York State true allele casework validation study. And in the study, we looked at about 80 different case example or 80 different evidence samples, and then ran true allele on them, calculated those true allele results, which is that blue cloud picture, and then compared with the human review, which is those different colored bars. There were 3 different methods used with that match statistic along the left. And
sorry.
And what we saw is in about 70% of the time, human review didn't get an answer where true allele did. And you know, that just kind of expanded on that first paper we talked about from 2011.
And 2015?
Yes, so the next study was published in the Journal of Forensic Sciences in 2015, titled True Allele Genotype Identification on DNA Mixtures Containing Up to 5 Unknown Contributors. And again, this study also looked at sensitivity, specificity, and reproducibility. But we also looked at how does true allele behave when you have, you know, different contributor numbers, different amounts of DNA. So in this study, there were 2, 3, 4, and 5 contributor mixtures of high template, meaning a lot of starting DNA, and low template, meaning less starting DNA. And so we plotted again that amount of DNA from a contributor on our horizontal axis versus that match statistic, the log LR. And for each group, you know, contributor number and low template, contributor number, high template, and then drew the line saying, okay, well, do they follow that trend where you have less DNA, lower statistics, more DNA, higher statistics? And when we compared those lines together, they weren't statistically different, meaning true allele behaves the same regardless of if there's a lot of DNA or a little bit of DNA, or it's independent of the contributor number as well.
And what is the max of contributor numbers that is used for true allele deconvolution?
True allele has been validated out to 10 unknown contributors.
This slide 22.
So also from that 2015 Journal of Forensic Sciences study, we also looked at low template DNA and examined the sensitivity. So 2, 3, 4, 5 contributors. You can see with 2 contributors, you generally get more information, higher numbers, and then that trend goes, you know, you can maybe get less information with 5 contributors, but you can still get information. And we were also able from this to measure false exclusion rates as well, or false negative rates.
And the specificity 23?
Similar to what we saw before, you're not seeing a lot past 0 on these plots, and it was measured for 2, 3, 4, and 5 contributors for those low template samples.
And what is the definition of a low template sample?
In the study, it was just 200 picograms, and is generally anything 200 picograms or below.
24?
And then we also measured the reproducibility, again, showing that for 2, 3, 4, or 5 contributors, the results, including exclusionary results, are reproducible as well.
What do you mean by reproducible?
That each time you run Trulio on that same data, you're getting a similar number each time.
Well, how does that relate to validation and reliability and accuracy of the program?
It's just showing that, we're not just running it once and saying this is the answer. We're showing that Trulio's, looking at that same data and basically generating a similar result every time.
And finally, 2019.
Yes. So this paper was first appeared in the Journal of Forensic Sciences in 2019 and was officially published in 2020, titled Validating Trulio Interpretation of DNA Mixtures Containing Up to 10 Unknown Contributors. And this study showed many different things. Again, showed the correlation between amount of DNA from a contributor to, the match statistic. And then we also looked at some other aspects of independent analysis. So does who's running the software and where they're running it, does it matter? And so Cybergenetics ran the same data in Pittsburgh. And then this was done with the Cleveland local laboratory. They ran it in their lab in Cleveland. And so the table on the left just shows we got similar results. Didn't matter who ran it or what computer they ran it on. And that was a less than factor of 10 difference between the match statistics. And then we also looked at, peeling, or when you can subtract out a person's genetic type and how that affected the data.
And I said finally, but I didn't mean it. The last one, finally, 26.
So slide 26 just shows that so we have a more updated way of calculating true allele error rates, published in Helion in 2018. So efficient construction of match strength distributions for uncertain multi-locus genotypes. And all it does is how to calculate those error rates by calculating virtually every possible person that could exist, comparing it with the data, and then saying what are those, specificity and sensitivity distributions. And these results were confirmed by comparing with that sampling method, or those 10,000 random people.
And I'm going to skip 27 because that's pretty much in my brief that I've already covered with the court, which I filed in September. So 28, could you give us a summary of true allele today? Like, where is true allele today? First of all, is true allele new?
No.
Okay. Now give us a summary.
So true allele, the math and everything has been around for 30 years now at this point. The computer system was developed about 25 years ago. There's currently 10 laboratories using it. There's over 530 agencies now across the United States and other countries that have sent data to Cybergenetics and had us, examine that data and produce those reports. It's been tested in over 40 studies. Many different talks have been given about it. And then there's, the 42, times in the United States where true allele was admitted after challenge. And those were both in 15 states and federal courts. Cybergenetics alone has done 145 trials in about 20 or to 25 of the states. And that doesn't count all, the user labs or the number of times that here in Georgia, in Ohio, in California, and the other labs that are using true allele, how many times they've gone to court on it. And just from, Cybergenetics we've done now, it's over 1,300 cases in 46 different states for both prosecution, defense, innocence, and police groups.
And has Cybergenetics or true allele also been used abroad, internationally?
Yes, it has.
And you told us about South Africa. What other countries?
It's been used in courts in the United Kingdom, both in Oxford Court and Northern Ireland, in Australia courts, in Israel courts.
And finally, your last slide.
This is just a summary from that 2014 validation study that true allele is, reliable, it's objective, sensitive, specific, reproducible, and accurate, and more effective than human review.
And if a person does true allele, since computer program, have a source code?
Yes.
And will Cybergenetics permit someone to examine the source code?
Yes.
Tell us about the process.
So what source code is it's just the human readable language given to any computer program, any technology that gives the instructions for that software. And so that is then turned into the executable program or application on your phone, or even your phone at this point. And at Cybergenetics, we now have a policy where we will allow opposition experts or any kind of other expert to contact us to come in, sign non-disclosure agreements, and then review that TrueAllele source code. I believe it's currently at our office in Pittsburgh. That's been the policy, and it's been on our website since I believe last year sometime, and is also included in our disclosure materials.
And before I get to the disclosure materials, or maybe I should just do the disclosure materials now, because I want to ask you about something on the disclosure materials. I'm going to hand you what's been, may I first witness?
Yes.
What's been marked as State's Exhibit 35. For the record, did you look at State's Exhibit 35?
I did, yes.
And what's on State's 35?
It's the entirety of the TrueAllele disclosure materials that were put together by myself and others at Cybergenetics, and then the GBI downloads to disclose in their cases.
And what types of material does the disclosure material contain?
So there are 4 different folders. The first is reliability, which has, background readings, validation studies, admissibility rulings, and anything you would need for an admissibility challenge. Then validation materials and data, tutorials on how to use the software, and then a folder that contains a read-only version of the software where anybody could review the results. And then there's also an invitation for others to come and test the system on their own. We'd set them up their own little TrueAllele server, and they can test whatever they want, and also that source code information.
And the state would move to admit State's 35 for the purposes of this hearing only.
We heard no objection, Judge. 35 submitted.
And if a person wanted to run a TrueAllele on their own for themselves, would you permit them to do that?
Yes, if they'd reach out to Cybergenetics, we would set them up their own, TrueAllele server on the cloud, give them the license to access the software, and then permit them to run whatever they wanted. Data in this case, other validation data.
Is TrueAllele reliable and reproducible?
Yes.
And is it widely and generally accepted in your scientific community?
Yes, it is.
And is it subject to standards and controls and protocols and procedures?
Yes. So there are certain standards and guidelines issued by some of the government agencies that deal with DNA methods, and they're for validating systems like TrueAllele. TrueAllele complies with that, and that information is included in the disclosure materials as well.
That's all I have. Thank you. I'll pass the witness.
Kirby?
Judge, I think that this relates to the motion to continue. I cannot confront this witness in a meaningful way without an ability to understand what she's saying. And if I heard it correctly, one of these math theories was used on the Enigma project. I don't know if that was to create it or to break it, but either way, my understanding of that was that it was pretty complicated. And so I don't have any questions at this point.
Okay. Can she be excused?
Yes, sir.
Can they go down?
Thank you.
Would you like me to proceed?
Yes.
State calls Ashley Hinkle.
Say the last name again.
Hinkle.
Hinkle.
I got what I could find on Discord into a file and
And Judge, I think we do have a stipulation with this witness that might make the process
as
go a
the
little
gavel,
faster.
their file on this case, and just transferred it into our file on our case. So
Raise your right hand,
go
please,
to,
ma'am.
as the gavel drops in Discord or into mine, you'll have the same. Thank you as the gavel drops.
State of Georgia versus Jose Alvaro, with truth, the whole truth, and nothing but the truth. So,
I do.
okay, thank you. Please take a seat.
We're going to take a quick break. I need to do this. Thank you, As a Gavel Drops, as a partner in crime that you are, for all of the fabulous court documents, videos, and anything you need for any case that's currently happening. Right now, they are following close to 500 different trials. So if you need any information or would love to read documents and you're a document junkie, please go to As the Gavel Drops. I'm sorry. My bad. But we are kind of partnered, and we support them. They support us. And of course, when we get documents, we share it. We kind of all share together. Also, Guadalupe Leaf Company here in Kerrville, Texas, for all your kratom needs. Please come and join us. We have the most fabulous product, cleanest and the purest kratom in the hill country. Okay. Oh, I have one. I put it up. It's probably at the bottom of the list, babe.
Spell your first and last name.
Go back and look. It's at the bottom of the list.
Ashley Hinkle,
And they would have created the title, and they're separate from mine.
S-H-I-N-K-L-E.
Where do you work?
I work at the Georgia Bureau of Investigation in the Forensic Biology section at the headquarters in Decatur, Georgia.
How long have you worked there?
Approximately 18 and a half years.
What do you do?
I am a forensic biologist trained in serology and DNA testing.
Tell the court a little bit about your education and your training, which qualifies you for your job.
Nice to have.
I have a Bachelor's of Science in Biology from East Carolina University and a Master's of Science in Forensic Science from Marshall University. I also have extensive in-house training at the Georgia Bureau of Investigation and the National Forensic Science Technology Center in Largo, Florida. I also participate in continuing education, and I am trained in a software program for complex mixtures called TrueAllele.
Are you classified as a master scientist at the GBI?
Yes, I am.
And how did you get that classification?
I received that classification by staying around for 18 years approximately.
In your 18 years at the GBI, have you had the opportunity to examine items of evidence for blood, semen, and saliva?
Yes, I have.
Have you had the opportunity to process items of evidence for DNA?
Yes, I have.
And have you had the opportunity to run the TrueAllele program?
Yes, I have.
I'm going to ask you for each of those things, approximately how many times have you run the TrueAllele program? Let's go backwards.
Run the TrueAllele in the mid-hundreds, 400, 500.
And testify, test items of evidence for DNA?
Testified for DNA?
No, test items.
Test items, sorry. That'd be in the tens of thousands.
And test items for the presence of biological fluids?
I do that less often, so it's hard to say, but at the beginning of my career, I did quite a bit. Okay. So in the hundreds.
Could you please tell the court a little bit about your specific training on TrueAllele? When did you first get trained on TrueAllele, and tell us how long that process took and what your training entailed?
The TrueAllele training began in 2017.
Yes, it is. My bad.
Since we are implementing TrueAllele at GBI, the training kind of ran concurrently to also writing the policies and procedures. So we assisted in that. As part of the training, we did quite a few readings on probabilistic genotyping and TrueAllele software. We had a visit and presentation from Dr. Mark Perlin, who is the head of the cybergenetics, which developed the TrueAllele. We also had practice tests on mixtures were provided to make sure we obtained a correct answer.
And do you receive ongoing training for TrueAllele?
Yes, I do.
And in general, how to interpret DNA samples?
My bad.
Yes.
Are you a member of any professional societies?
Yes, the American Association of Forensic Scientists and the Southern Association of Forensic Scientists.
Are you personally certified?
I am certified by the American Board of Criminalistics in the area of molecular biology.
Have you testified before as an expert in a court of law in the fields of forensic biology, forensic DNA analysis, and true allele?
Yes, I have.
And in each of those, I'm going to kick out forensic biology. Let's just talk about DNA, forensic DNA. How many times have you been qualified as an expert in court in the field of forensic DNA?
All over, I've testified and been an expert approximately 300 times.
And what about true allele? How many times have you testified as an expert in true allele?
Approximately 60 of those were with true allele.
At this time, Your Honor, the state would tender Ms. Hinkle as an expert in the fields of forensic biology, forensic DNA, and true allele.
Any objection?
No objection to the admission as an expert.
All right. Should be allowed to testify as an expert in forensic biology, forensic DNA, and true allele.
May I approach the witness, Your Honor?
Yes.
I'm going to hand you what's been marked as State's Exhibits 36 through 45. And since there has been a stipulation about these, this will go a little faster. I'm going to just show you State's 36. Is that your CV?
Yes, it is.
Okay. And 37 through 45.
I wonder how long
Really look at those
this is
and
going to
tell
go
me
to.
those are the crime lab reports that you created in this
Is this
particular
trial?
case that we're gonna talk about.
I thought it was a hearing.
Standing for some.
A lot of testifying. Well, Ronnie, you're my research person. You pick in Discord. Are we going to put it under the victims or the perpetrator? Because sometimes we have the victim, sometimes we have the perpetrator. So we need to pick and choose. So I'll let you make the decision, and you should be able to go in and edit that. I think you have access to edit. If you don't, you dang well should. Ronnie should. She should have all permissions in my Discord. Wow, Ronnie, you have sent 1,609 messages. Jiminy Christmas. You joined on June the 2nd. Oh, you were in Discord on June 7th of 2021, Ronnie? Dang. Okay. You are moderator, so go for it. I just wanted to make sure you had the mod. We're good. I don't know why they cut the volume, but they did. Like, hello. That'd be strange. Why do we have not volume? I didn't cut volume. We have full volume. Do y'all have volume? Or is it just me? No, we don't have volume. Computer's up. It's up. They cut it. Let's do this.
So in the hundreds.
I've been there.
Could you please tell the court a little bit about your specific training on true allele? When did you first get trained on true allele, and tell us how long that process took and what your training entailed?
The true allele training began in 2017. Since we are implementing true allele at GBI, the training kind of ran concurrently to also writing the policies and procedures. So we assisted in that. As part of the training, we did quite a few readings on probabilistic genotyping and true allele software. We had a visit and presentation from Dr. Mark Perlin who is the head of the cybergenetics, which developed the TrueAllele. We also had practiced on tests on mixtures were provided to make sure we obtained a correct answer.
And do you receive ongoing training for TrueAllele?
Yes, I do.
And in general, how to interpret DNA samples?
There was no sound, so we zoomed forward.
Are you a member of any professional societies?
Yes, the American Association of Forensic Scientists and the Southern Association of Forensic Scientists.
Are you personally certified?
I am certified by the American Board of Criminalistics in the area of molecular biology.
Have you testified before as an expert in a court of law in the fields of forensic biology, forensic DNA analysis, and TrueAllele?
I have it up
Yes, I have.
100% on
And in
all
each
of
of
my
those, I'm going to
ability.
take out forensic biology. Let's just talk about
Is that better?
DNA, forensic DNA. How many times have you been qualified as an expert in court in the field
Is
of
that any
forensic
better?
DNA?
All over,
Is it
I've
what?
testified and been an expert approximately 300 times.
And what about TrueAllele? How many
Wait,
times have you
why did
testified
you
as
go
an
back
expert in
there?
TrueAllele?
Approximately 60 of those were with TrueAllele.
At this time, Your Honor, the state would tender Ms. Hinkle as an expert in the fields of forensic biology, forensic DNA, and TrueAllele.
Any objection?
No objection to the admission as an expert.
How does that work?
May I approach the witness, Your Honor?
Yes.
I'm going to hand you what's been marked as state's exhibits.
I don't know that. Then we're up to par now.
35, and since there has been a stipulation about these, this will go a little faster. I'm going to just show you state's 36. Is that your CV?
Yes, it is.
We got
And
captioning.
37 through 35, if you could just quickly look at
Oh my
those.
gosh, we love you. Thank you, Trial TV Live. OMG. Thank you. Now I can follow along. You're amazing. Oh, as long as you're captioning, this chick's here. Thank you so much for turning captioning on. You rock. Y'all, if you guys love to just watch trials with no commentating, just a straight clean feed, go to Trial TV Live. They are phenomenal. They're new. They're growing like wild, and we adore them. And I use their feeds as much as I can. Okay. Is this better? Is this better? Is this better? Testing, 1, 2. I haven't changed anything on my microphone. Someone give me a heads up. It may go robotic when we turn it that high because I'm pushing it too far through the system. Okay. I've got this set as cleanly and as high as I can. Oh, I'm just excited over the captioning. For those of you who don't know, I am deaf without my hearing aids. I grew up hearing, became deaf as an adult. And I really can't understand unless I can read most of what's being said. I can interpret, but I read while I interpret. We don't have a deaf person watching right now, or I would be interpreting. But this is silenced on their end, not on our end. Why do we not have any sound? Is it me? No, it's on their end. I know this must be driving Trial TV Live crazy. I'm going to them and see if I need to re-bump into the feed. No, the other one doesn't have sound either. He's trying to switch feed. Okay. I think I'm just going to pop out their chat so I can keep up with what I need to keep up with. We're doing multiple things here. He's trying to change feeds. Let's be patient with them because they're fabulous. And this is frustrating. But it's awesome. Yeah, they're a mess. They're a mess. But I am so ecstatic that see, the hard thing is not every court offers captioning. And so if one court feed has captioning over Trial TV Live, I kind of have to use them if I don't have a choice. But if Trial TV Live has the captioning, they're my go-to. You know, they're my go-to. So, yeah. That's kind of where I'm at on that. I really, 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 really appreciate settings. Advanced. That's not what I want. So they're working hard over here. Okay, so they are working on it. I'm working on something real quick. Trying to anyway. They're saying hang tight. We're hanging tight. We got you. There it is. Y'all hear my son?
Not my fault, not my fault, not my fault.
There we go. Okay, I had to fix something. Okay, it's done. Let's see. We do all that. Oh my gosh, so here we go. Get back to the stream. All right. I know, but sometimes they can't, and that's the hard thing. And I rather support them because they're a small channel and they are very kind and friendly and they have wonderful chats. And I just really appreciate what they do. And it's frustrating when sometimes I know they want to provide the captioning, but sometimes they can't. And then I have to choose and I hate it. I wish there was a mode because I can put captioning on my computer where it captions everything, but you can't see the captioning and the deaf people can't see the captioning. So that's the issue. So, yep, that's where we are. Okay, we are still looking at this fabulous screen. Yep. We'll see what they do with this live here. If they are not able to get it back up and going, then we'll go into the Boone live that I was trying to start all day because y'all, we have audio has been located. Yay! So anyway, yay. We have audio. We may not have video. They're working on it. Oh, wait. For those who are using Windows, whenever there's mono audio on one side, there's an accessibility settings, accessibility auto audio that fixes it for. Oh, I got to screenshot that. There. Okay. Okay. My sound is up. As you can see, we're waiting on them. I'm going to go fix this. Yay! That helps me. Sound does come back. Both feeds do not have it at this part. Okay, so we'll wait with you. We're good. We're good.
Number.
Okay, so does that mean there's a threshold
I got
at
it
the
in
GBI
reverse.
in which
I
you
did
will
the
not
fix.
call a case if
Okay,
it's
guys,
within the error
I'm going to
rate?
copy.
There is a threshold where we will not call a match, yes.
A match, okay. Thank you for correcting me. Because you do create, or you
This
do
is
report,
from their
do
mod.
you report matches on false,
Y'all do that on your
or
computer,
the
'cause I
potential of a
haven't
false
been.
exclusion?
We have a range with our exclusions where there is a calculated average possibility of a false exclusion.
So of all the items of evidence that you tested in this particular case, did you follow your policies and procedures at the GBI and testing the evidence?
Yes, we did. I did.
And I want to say specifically to the true allele results, prior to going to true allele, did you test the items of evidence using traditional STR, DNA, typing, and analysis?
Yes.
And then how was it then that some items went to true allele, and don't tell me the specific items, but some items went to true allele and some did not? How do you make that decision as a scientist?
That decision is based on whether we can separate a mixture into individual contributor DNA profiles and then compare that to reference samples and match using the traditional DNA testing. We have methods where we can attempt to do that based on the percent contribution of DNA from two individuals. We can separate out contributors. We can also make an assumption that someone is present on an intimate item where we would expect their profile to be present. If we can use those methods, including another method or up to 3-person mixture, we can pull out a major contributor who's more than 75% of the mixture. So if we can use those methods, then we do not need to use true allele.
Okay, guys, this feed does not
The
have
policies and procedures then tell you if you can't use those methods that you then go to true allele.
Yes.
Did you receive known DNA samples or reference samples in this case of Lake and Riley?
Yes.
Jose Antonio Ibarra?
Yes.
Diego Ibarra?
Yes.
And Argenis Ibarra?
Yes.
Okay, and did you process those items yourself?
Now,
yes, I did.
I'm in 2 ears.
And did you use did you follow your lab's policies, procedures, and protocols in processing those items as well?
Yeah, yes, I did.
Are you familiar with all of the policies and procedures that the GBI has on the True Allele software program?
Yes, I am.
And are you specifically trained in those and trained in them if they change over time or update over time?
Yes.
And have you all updated your True Allele procedures and policies over the years?
Over the years, because we started out from scratch, we have updated especially the reporting statements as well as what we need to include in our notes.
And every time that you all get a new testing kit like Global Filer or Identifiler, do you also have to then revalidate True Allele at your lab for the new kits?
Well, we only use it on 2 kits, which are Identifiler and Global Filer, and those we have used since the beginning, and we have a validation for each. But if there hasn't really been any changes in those kits, but if there is any changes to the True Allele software program, which also has a server connected to it, then that must have a performance check before it's used for casework.
And the performance check is done by the GBI?
Yes.
The items of evidence that you process in this case that are the results contained in your reports that we have already admitted, were those methods that you use generally or widely accepted in your scientific community?
Yes.
Were those methods published in relevant scientific journals?
Those methods have been, yes.
And are they reproducible and reliable, the methods?
Yes.
And in compliance with the GBI's policies and procedures, after you conducted your testing in this case, were your results peer reviewed?
Yes, they were peer reviewed by a scientist who is also trained in the methods.
And that is all I have, Your Honor. I'll pass the witness.
So we'll follow this trial starting Monday.
Especially as it relates to Ms. Hinkle.
That worked.
My understanding is that Ms. Hinkle would be the application of the underlying science to this particular case. So from 40702, without an expert to evaluate whether that was done correctly in terms of the data that we've been given that is not even in narrative form, I need an expert. And so until I have an expert, I will either reserve cross or I don't have any questions for Ms. Hinkle.
Anything else of this witness?
No, sir, may she be excused.
You may be excused. Thank you. Any other evidence?
Not on the Daubert for True Allele, no, sir. No evidence.
And I'm going to offer Mr. Kirby, but I don't expect it. Do you want a summation on this issue?
No, sir, it's in my brief, and again, I would encourage the court, if you could take judicial notice of it even without the need of a hearing for Daubert purposes.
And I'll offer you if there's anything else you want to say. Here's my plan or my thought on your issue related to a continuance in order to get an expert. I'm going to ask you if you can answer this question and read in what you said earlier and what I saw in your motion. As of right now, you have not identified an expert. Is that correct?
We have identified a potential expert, yes.
All right. But, which leads to the reason you're asking for the continuance.
Yes, we contacted an expert. They informed us that that's what they would need, and I would be hopeful that that is a number. In talking to other people, that seems like, I don't know. I'm hopeful. We've been trying since we got this information. So I just want the court to know that. I want everyone, the state to know that this is not about purposes of delay. We don't want necessarily this to drag on any longer than it has, but we have a duty to our client.
But in reading your motion, you're asking to not only continue this hearing and leave that opportunity open, but you're also asking to continue the trial.
We recognize that the effect would be to continue the trial. And again, I've explained why that is,
That's right.
and we feel like we have to do that.
Well, let me give you some direction on that. It is not my intention at this stage, or based on what I've heard so far, to continue the trial for that purpose. However, I will leave open the opportunity if you want to bring someone in as an expert. and
Okay,
have
I
a
missed that.
hearing
What?
Hearing on that, not for
I'm going to go back
continuance
just a
purposes,
smidge,
but-
y'all. Don't get mad at me. It's my hearing. I want to hear what that judge has to say again. That I heard something.
Again, I would encourage the court, that you could take judicial notice of it even without the need of a hearing for Daubert purposes.
So this is a hearing.
And I'll offer you if there's anything else you want to say. Here's my plan or my thought on your issue related to a continuance in order to get an expert. I'm going to ask you if you can answer this question and read in what you said earlier and what I saw in your motion. As of right now, you have not identified an expert. Is that correct?
We have identified a potential expert, yes, Jim.
All right. Which leads to the reason you're asking for the continuance.
Yes, we contacted an expert. They informed us that that's what they would need, and I would be hopeful that that is a number. In talking to other people, that seems like, I don't know.
Dragging their feet. They knew the.
We've been trying since we got this information, so I just want the court to know that. I want everyone, the state to know that this is not about purposes of delay. We don't want necessarily this to drag on any longer than it has, but we have a duty to our client.
But in reading your motion, you're asking to not only continue this hearing and leave that opportunity open, but you're also asking to continue the trial.
We recognize that the effect would be to continue the trial. And again, I've explained why that is,
That's right.
and we feel like we have to do that.
Well, let me give you some direction on that. It is not my intention at this stage, or based on what I've heard so far, to continue the trial for that purpose. However, I will leave open the opportunity if you want to bring someone in as an expert and we need to have a hearing on that, not for continuance purposes, but perhaps to do some examination or put on your own evidence. I'll leave that opportunity open depending on what it is. I understand what you said, that you don't think you can accomplish that, but that's where we are today.
Okay, so just.
So they're not going to. So
try to
you're
get
not going to continue trial.
Is the court's ruling. There is not a denial to the continuance for this purposes of today.
I'm leaving this open for you.
Okay.
But I'm not bringing back anyone else for that. It would be around the trial as a practical matter if you want to reopen some of that outside the presence of the jury.
Okay, thank you, Judge.
Does that make sense?
Oh, I said
I'm not
Texas.
trying to be
I'm sorry.
obtuse about this.
Well, Judge, and I think that from a practical standpoint, it doesn't matter. It's just, we have explained our position in terms of confrontation, Sixth Amendment, corresponding sections of the Georgia code that we're asking, that we're objecting to this and asking for that continuation.
And I'll be putting this in a written order, but I just think as much as I can tell you today, because we're a couple of weeks off, you need to know. And that's why I'm trying to do that.
I appreciate that, Judge. Sure.
Okay, I'm
All
lost.
right,
Someone
where does
fill
that
me in.
leave us then?
Argument on fingerprints, Your Honor.
Okay.
That's, I believe that's decided.
They just turned the volume up a bit. Thank you, 12 TV Live.
It's closed. The state have nothing to rebut, so that is closed.
You having that, Mr. Donovan?
Yes, sir. Just briefly.
Oh, they wanted a continuance, and he's not going to do that. I was like,
Under 702, we asked the court for permission to leave the evidence open, to possibly present someone. We're electing not to at this time. But the case law tells us that the burden would be on the proponent, but that would be the state, of the proposed expert testimony. I'm citing their National EMS versus Smith, 368 Georgia Appeals, page 18. And this would include the burden order to present evidence of reliability, not just evidence of the witness's qualifications. And another citation from a recent case is Humphrey versus Emory Clinic, 369 Georgia Appeals, page 131. And so in 702,
I'm having a hard time understanding this guy.
B, has four prongs to it. That, and it's not alternatives, but the court must be satisfied that all of them have been met. And we don't have any issue with the first two. That is the experts training, or that the testimony is based upon sufficient facts or data. But really the second, prongs 3 and 4, 3 being the testimony being the product of reliable principles and methods. And we would point out that the witness acknowledged that, Detective Stewart that is, acknowledged the federal study pointing out a concerning error rate of false positives in fingerprint comparisons. And that was, he acknowledged that was 2016 in this federal study that they refer to as the PCAST study, and that's an acronym, PCAST. And that study called for additional peer-reviewed scientific studies of fingerprint comparison for this to really be forensically sound, scientifically sound. And the state could not cite any, the witness could not cite any peer-reviewed studies that have addressed the problem that was pointed out in 2016. What he did testify to, and the state introduced these into evidence, was that in 2017, a body, it's a national body, OSAC issued guidelines setting out the ACE-V, another acronym, ACE-V method, and the witness said he followed that this is a widespread method and that it has been accepted. But also, again, there were no scientific studies to prove the reliability of this method, and specifically no testimony as to a known error rate, which obviously that's one of the things that the case law talks about in looking at for prong number 3. And in fact, the state made a point to bring that up in this last with the DNA witness. And then the fourth prong, the court has to be satisfied that the expert reliably applied the principles and methods to the facts in the case. I think this is a little bit bigger of an issue here. The report that the state introduced at the first part of this hearing of Detective Stewart's analysis is basically, well, the analysis portion of this report basically has 2 very conclusory sentences, and that report is in evidence. There's no detail, no documentation in tandem with the analysis from which another scientist or examiner, I guess, could determine whether the method that this witness used is capable of being reproduced, capable of producing reliable results. Yes, it was done a second time. There was a second analyst who reviewed the fingerprints and came to the same conclusion, but really without any documentation in tandem with the first examiner's analysis. There was nothing for her to follow. She was basically doing it anew. The documentation, there was documentation presented in court to accompany his testimony, but that was not created at the time that he came to his opinion, that he formed his opinion, that was prepared simply for court, as a demonstrative aid.
Are you talking about the peer review?
No, I'm talking about the charts that he brought in with blow up of the latent lift and with the known print. He had color markings on them. Those documents, but other than that, he didn't have any objective documentation of what he did initially to form his opinion so that another examiner could review that. As far as the court's assessment of this fourth prong of 702, there's also the lack of an APHIS confirmation. The known print was included in the APHIS system, yet APHIS did not find a match or even a close enough, within 20 candidates, within a close example to the unknown latent lift. So, I understand the state's position is that this is a long-standing forensic method of fingerprint analysis. It's gone on for years and years, and it's been introduced in courts all the time, and that it would be shocking for this court to exclude it. But there's not a Georgia court that I can find after 702, that goes into any detail about the admissibility under 702, since this has only been applied to criminal cases since 2022. So I'm sure to the state that this is a stretch, that we are asking the court to exclude that witness's opinion. What I am asking the court to do, if the court finds that the witness is allowed to give this expert opinion,
I want to let you know that trial is slotted for the 11th of November at 8:30 a.m. FYI.
you're asking the court to order that opinion be tailored. And in that regard, I have a case to cite, Hart, H-A-R-T, versus, Phone, P-H-U-N-G, 364, Georgia Appeals, page 399, that's in 2022. And that's a civil case with a car accident where there were, experts trying to talk about the lighting conditions. And the court in that case held that this one particular expert could not go as far as to describe what the lighting conditions would have been in the situation. But he was allowed to testify to things that could help the jury. That these lights on this vehicle would have provided this illumination. The light on the street would have been, provided this illumination. The distance that the pedestrian was from the vehicle was this. He could have given opinions that would not have otherwise been, known to a layperson, such as the illumination that the vehicle would have provided. But he couldn't go so far as to give a more specific opinion as to what the driver could have seen. And so in this case, and I understand that it's somewhat different, but what they did in that case, the Court of Appeals on review said, look, we're not finding error with the trial court's admission of that expert to give an expert opinion, but that it should have been more tailored and that it went too far. And so I think that this court would be authorized to do that. And what we think that based on Detective Stewart's testimony, so again, I'm referring to the document that the state introduced as far as his written report, the essentially 3-page report, although the third page, there's no content on it. But so the second page of that report, where he comes to his conclusion, he says that the latent and the thumbprint of Jose Ibarra have a great deal of corresponding ridge detail. Well, I'm not going to read the whole thing, but there's two sentences there that his policy authorizes him to make.
Really?
Similarities.
Gosh, I'm so
between these two,
sorry.
fingerprints. But the last sentence,
Well, thank you
when he
for
says,
persevering,
the left
love.
thumb of Jose Ibarra is the source of the latent on the cell phone, we would object to that, to him being allowed to say that. And that is in keeping with his own policy. He testified, and it's in evidence, the police department's policy, also the OSAC guidelines, which are also in evidence. Neither of those authorizes an examiner to go that far in his opinion, and the science just doesn't authorize a claim that bold to make a statement that this person is the source of this latent print. They can't even see the entirety of the latent print, as we saw in the blow up. So we would ask that if the court does allow the witness to testify as to an expert opinion, we're asking it to be limited to those first two sentences in his conclusion, and to prohibit the witness from testifying to that last, more broad and
Cold.
If that makes sense.
I understand. Thank you.
Fix your hair, dude.
Charles.
Got that one up. Poor guy.
Again, Your Honor, the state had filed a response to their Daubert request urging the court to take judicial notice of the reliability of fingerprint evidence. And counsel said there is no Georgia case on point, but the last time I checked, the 11th Circuit Court of Appeals is in Georgia. And the 11th Circuit Court of Appeals held in 2023 that fingerprint evidence is so widely accepted. And I cited to the court an opinion from 1911 where fingerprint evidence was discussed, that fingerprint evidence is so widely accepted in the federal circuits, which is what our Daubert statute models under 702, 24/702. The Georgia General Assembly tells this court we have to look to the federal circuits. And then looking to the federal circuits and looking at the 11th Circuit, in 2023, they have held it is so widely accepted that you don't even have to have a Daubert hearing on it. You don't. We asked you to take judicial notice of it, but we had a hearing anyway, which is great. We have a great record. And on this record, there is no basis to grant them the relief that they are seeking. And it's interesting that they are now challenging the reliability of fingerprints in general, because when we had our discussion about why we're having a Daubert fingerprint analysis, it was more they were attacking the expert and the way that he did it and not fingerprints in general. But even if they're attacking now fingerprints in general, they had the opportunity to ask the expert if fingerprint evidence is unreliable. I'm assuming he wouldn't agree with them. And he did talk about generally how reliable fingerprint evidence is done. And he talked about the ACE-V method. And the reason why that is so important is because the V is for verification, and his work was verified. But there's also, since 2022, since Daubert was enacted in criminal cases, I do have two court orders from other superior court judges in this state who, like Your Honor, have had Daubert hearings and fingerprints, who have talked about specifically the ACE-V method. And you can find the ACE-V method in all the cases that I cited to the court in my brief about it being inherently reliable. And so if I could, one is out of Fulton County and the other one is out of Augusta. There are two, obviously it's persuasive authority, but I just thought I would share these two court orders with the court on fingerprint and ACE-V.
That's fine.
May I approach?
Sure.
So we request that you deny their Daubert on fingerprints, and the request to limit the expert's opinion to something that is really no opinion at all. It's just not logical and supported. In fact, he's an expert in fingerprints, not lighting. I could see a civil case that I haven't even read because I didn't know he's going to cite it, where you don't need an expert to talk about the lighting. That's really kind of something the jury can figure out. But he's talking about fingerprints and matching a fingerprint to a known item of evidence. And so we request that you allow him to testify to his full opinion, which was outlined in his report and which was explained to
He
your
can bring
honors.
in anybody he wants for his defense. If he wants to bring a lighting expert in, he can do that.
Does that cover the subjects that we were?
The only other one was the motion to particularize the witness list. And I don't,
Why would she care? This case in point.
I mean, I
Case
guess
in chief.
I haven't seen the list, so I don't know. Does the state have a position
Yeah,
on
I have
what they may do
told them,
about
but
that?
just haven't done it yet because we've been so busy preparing for motions. I will limit and tell them, I will give them a range of civilians that I'm going to call. I have told them I am hamstrung because I'm not sure what they're going to do. And I'm always able to call anyone on my witness list. That's why I put them on my witness list. But so that the trial will move efficiently and they can be prepared, I will give them a narrowed list, but I'm subject to calling anyone on the list, which is why I list them. And I don't want to box myself in because I don't know what they're going to do. So obviously they could do something that's going to require me to call someone who's on the general witness list, but wasn't on the narrowed witness list. So my way of saying I want to be agreeable, I want to help, and I want to narrow it for them, but I can't be bound by what I tell them because I have a burden of proof here. And if they do something that's going to require me to call someone that I've already listed, I reserve my right to do that.
and Judge, I think we put it in our motion. I'm happy to put it on the record here again. We don't object to that position. We're not asking the state to commit themselves to only calling these witnesses. We're not asking the state to limit their rebuttal possibilities. We're just in good faith trying to prepare this trial. The data is voluminous, and so if we would just have some notice of who the state actually has under subpoena, that would just allow us to be ready on November 15th.
Okay, it sounds like that's done.
Yes, sir.
Yeah, and it would be helpful if the state had gotten any witness list from the defense, and I know we're not 10 days out yet, but once I get a witness list from them, then I can better limit and tell them who I'm going to call.
It sounds reasonable, doesn't it, Ms. Pat?
Sounds reasonable, doesn't it, ma'am? Yeah. You better say yes, Your Honor.
If we have witnesses to call, we're happy to alert the state, but at this point, I don't know, we don't have any witnesses beyond the state's position.
All right, I'll leave that to you all. Couple of things. One is I just to kind of give you all an idea of how I want to try to proceed on the 13th.
I don't know. In
reality,
reality,
the clerk's office,
I'm
we're
on
going to go ahead
live and I don't have
bring
anything.
in all the jurors Wednesday. Y'all have done a good job in coming up with a juror questionnaire. I mean, I think it's 53 questions.
Yes.
And I think that will tell you all a lot, but of course it's going to take some time. They'll get checked in. They're all going to be given the questionnaire. Then they're going to be loaded. This is just kind of housekeeping things, but I think it's helpful to you. They will put them on iPads, 2 or 3 per side, load them on. If you all want to
Well,
take
it's
your
70%
iPad
guilty,
and download
11% not
printed
guilty,
copies
19
or print out copies, you're going to
on
be able
one of
to
the
do that.
other stations poll.
As soon as we're able to identify,
Do we have a
get them in
do we
panels
have a
and do
verdict?
the first 12.
Well-
Those are the questionnaires I'm looking for first, even though they'll all be doing them. We'll go ahead and start the void eye with them. We're going to do everything in the courtroom across
There's
the
nothing
hall
going on with the
that are
camera
in
yet.
Judge Stevens' courtroom. From jury to trial. I think it just makes sense now that I've thought about it, to do everything there. I also will tell you now, it is my intent to have jurors referred to by their summons number. And the questionnaires will of course not be available to anyone either.
I don't even see them running the live.
Also, I will, since you all have done such a good job on the questionnaire, I am not looking to spend time in void hour asking those questions. I understand there will be follow-up, but I'm also not looking for what I call rapport establishing questions. They're going to get to know you pretty well during the process of this. Certainly, I'm going to let you introduce yourselves and everybody, but we're going to be able to do that early on. I'm just looking to not
I can't even find their
spend
live
more
feed.
time than you need to with them. It's going to be cumbersome enough.
Are they broadcasting it live?
Um,
Okay. Well,
The
They don't even
last
have a verdict.
thought
Rating.
I have is, y'all got a notice about plea day on that
Let me go to
calendar
this channel because
for the 12th.
I'm live.
Unless
not-
you all tell me
playing.
differently, I don't know of a reason to call you all together for the 12th. If that changes, let me know. But, I mean, we could make room, but I'm also not saying that to invite a time to hear
He's
other
saying the
motions and all of
deliberations
that
are still
necessarily,
continuing.
because I'll have other things to do. But, I just am letting y'all know that, we need to be here for that.
So we are officially excused from the 12th?
That's correct.
Thank you.
I have one logistic question. We had talked about the possibility of individual voir dire.
Okay, so-
On some of the questionnaire questions, and the reason I asked that because obviously some of the questions will deal with what actually do you know about the case, and I don't want to ask that in front of other jurors.
I thought he had a funeral.
You want to be heard on that?
What is the court's general policy on that?
Okay.
Okay, so there may be, but if the judge isn't available, then we'll
I
have
do
to wait.
sequester voir dire from time to time, especially when there is allegations of sex acts. Sometimes people are not as forthcoming with their issues related to that. So that alone. But I can also see a reason to do it in this case as well, just as I think Ms. Beck just mentioned. So the way I usually work that is, of course, we end up with 12 jurors over there. We put them in the jury room and bring them out one at a time. And if there is some follow-up with each one, then we address that then. Then, as a practical matter, I usually have them step outside and then I entertain any motions related to that particular juror. So we have sort of a running total of who we qualify.
Yes, but they're not back yet.
I polled the other panels. I try to stage it so that they come in and they're not waiting, but they would have to be waiting probably out here in this atrium. We may have another place for them to wait and gather as well. That's what I'll be looking for. But that's usually what's done.
When you handle sequester, why do you handle just that sensitive topic, or do you go ahead and complete all the questions for them?
I usually do everything for that juror. I think but in this case, with y'all got all of those questions ahead of time, I just do the sequester voir dire, anything that we think has to be dealt with on that particular juror, not just what I call sensitive questions.
Yes, Judge, and I would just offer that at least right now, our position is that we don't need to question the jury in groups of 12 if we're doing individual voir dire, because all of our general group questions would be in the questionnaire. So,
with the exception of, I did not put the statutory questions in, and so are you going to bring them all in to do the statutory at one time and let them know certain things like, this is not a death penalty case, and we're gonna take your phones, and you're not gonna be sequestered, all that kind of stuff they wanna know?
They live here in this county.
Yes,
things
yes,
like
yes,
that.
all that stuff will be.
Those statutory questions I'm going to do as a group, I hope. May have to do it in two sections, but I'll have to ask all of those.
And the one thing that I did not put in the questionnaire is an actual witness list, like I made.
So
I need to plug that in. Do I email that to the court, or how do I plug that in? Or do you want me to plug it in and email it back out to everybody?
You can email it to my office, of course, copy all parties, but that'll be fine. I'm hesitating because with the stipulation about trying to have the list, I don't know how exhaustive a list we're talking about.
So what I could do is, what we've done in other cases, is when you do the statutory questions, either you could read the list at that time to the entire panel, just ask them to raise their numbers, if they have numbers. Or I could read the list at the time, they could read it, we could just figure out how we could read the list at the time instead of writing it out. I've seen it done both ways. Sometimes we print it. Sometimes we just, when they're all together and you're doing your statutory questions, you usually hit the buzzer to the state and you just read out the witness list and say, raise your number if you know these names. And then we can just note it and then follow up on it when we follow up.
I think Your Honor's concern is, I would request that rather than reading the 265,
I'm not doing that.
okay.
It'll be the reduced list. It's not gonna be 265
Okay.
people.
Let's try that, because they're gonna be overwhelmed a little bit by the questionnaire as it is, much less,
So try reading it, not putting it in.
yes.
Yes,
And
sir.
it doesn't matter to me too much whether I do it or you. I tend to say it's your list, so Ms. Ross reads them out.
Your other judges are in your company, yes.
Okay. Anything else we need to talk about?
Two other additional matters briefly. I need to give the court a court order for
Sorry about
Case
that. I
Exhibit
thought it was
31 from today.
Oh my God.
Which is a thumb drive. So I will just submit that via email.
It's overwhelming.
All parties
on
that
all
will give the court the
polls that
opportunity
she'll
to
be guilty.
in camera review it and then decide if you're going to sign that order. And then we would like to just make a record to make sure that the translation is going well and there are no issues with translation. We don't see any, we don't hear any. I just want to make sure that the defendant is understanding the proceedings for the record.
What do you want?
In what form would that be? I don't understand.
Well, I guess I'm looking for, and I think it's a reasonable request while we're here on the record, is there any problem with the translation? I assume the equipment is working and your client's getting the information. If there's a problem, I would like to know it. We all would.
Certainly, we would bring that to the court's attention.
Okay.
Yeah, and I'm not aware of any either. I just don't know what we're looking for there, an affidavit or a.
No.
No,
It's an
I don't
inquiry.
think so.
Oh, yeah, I'm not aware of any, so.
Okay. Well, certainly that door is always open if there is.
Your Honor, now and then I ask him, are you understanding what I'm saying? He answers yes with the head, so I just need to make sure that you understand what I'm saying.
Okay. Because we are also dealing with electronic, I guess there are batteries involved. I don't know.
I have them.
Okay, all right.
Everything.
If something starts happening, let us know.
That's it.
All right, thank you all. I will take, before we get so nervous about this, I will take 31 and hold it.
I'm gonna sit here and get that order.
You don't have a little extra cash.
Okay, that'd be the end of that one. Yep. Wow. Okay. That trial is to begin November the 13th. So we will be live for that one unless something more amazing happens. I don't know. Yeah, better not. Okay. Sounds great. Wunderbar. Now we're waiting on this. That got a little spicy. What do y'all think about that? I think that's going to be a good trial. I think the DA, assistant DA, man, she's going to be a firecracker. Firecracker. I don't know. RA said, let me see if I can pull up RA. I'm trying to get it up. Hold on. Recovery addict. Oh, someone said they wore an orange prison break hoodie. So tell me about y'all's Halloween. Tell me what y'all did. I'm kind of looking at them, guys. Oh, we got a customer. I'm still looking. Hey, apparently. Oh, I want popcorn now. That's no fair. Oh, let's see. Gosh, now I want popcorn. Yeah. So, stay home, watch 1990 Sense and Sensibility. Oh, that's interesting. Come on, trying to get my. I'm cold. Oh, someone want to see pumpkins? No verdict yet. Okay, so why don't I go ahead and start my other live with the Sarah Boone? I'm supposed to go live at 2. Or I do this. What if I go live tonight? I'm going to put it to 6 p.m. just for the hell of it. Would you guys like an early sneak at what the information I have on Miss Sarah Boone, or should we save it and do it after this one? I kind of want everybody to be on. I don't know what to do, because if I put it on here, then nobody else later will watch it because they won't know. But I got some new skinny. We got some new skinny. Hey, Zach. Well, I can tell you what it is. Oh, I don't know if you heard that popping, but let me tell you, that felt fabulous. Oh, we got spilt the beans. Okay, I'll ask y'all this. If I start the other live with Boone, will you hop on that one as well? After the verdict? I don't know if we even have a verdict, y'all. Boy, Notorious Jules is going like crazy. This will, we got a premiere tomorrow on Sarah Boone. Tune in. Oh, guys. Ooh. I'm getting the mic close so you can really hear me. Announcing, tune in Saturday start again. Tune in on Saturday, 2nd of November at 9 a.m. Eastern for a sit-down casual interview with the Notorious Jules as she attended the Sarah Boone prison trials. Oh, let me ask her. I don't need to. This thing wants me to create something. Let me go up here. I want to see if Miss Jules will let me rebroadcast this. Yeah, yes, Miss Jules. I hope she says yes. That will be awesome. True crime addict. awesome. Oh, I love this girl. She's fabulous. You know that, y'all? Y'all know how fabulous that woman is? She's amazing. Sorry. So I'm hoping she lets me rebroadcast this because that would be fabulous because she's awesome. Okay. I can tell you some of what I got. Yeah, the court's been in and out the last few days. Okay. Some of what I have. I have detailed phone reports for Sarah Boone starting on 1/1 of 20 through 10/28 of 22. Uh-huh. Mm-hmm. But with dialed the phone numbers, the PIN, the date and time, result hung up, or whatever, call type. Wow. Now this doesn't give a whole bunch of information, but the other one does. So we got those. May not, yeah. But then what we did get is the video visitation log. Uh-huh. Of who the visitor was starting. This is in May. And then we have an inmate behavior log starting back on September through, are y'all ready for this? Through the 31st of October. Yeah. So, I haven't really looked at any of this because I like to look at it fresh with you guys. But I will say I see some red, which means negativity earned. Some more shenanigans have been going on. But I'm seeing 1, 2, 3, 4, 5, 6. Let me scroll down because I see a lot of visits for a while there by her son. Oh, on the 28th. Oh, you guys. Oh, poor baby. Oh, okay. What is it? What do you got? What is it? The dog is in a good mood. We have some no-shows on visitor logs. She's got clergy. Oh, Christina Pena comes up a lot. Friend. Mm-hmm. Yep. Oh, maybe I can find her. Oh, let's see if we can find who this person is. Although that's a very popular name, y'all. Oh, there's 20,000 of them popping up. No, we ain't gonna find her. Oh my gosh, a lot of no-shows. Ooh. So we need to go through these and wow. Do some looking. But I really would like to do a different live on this. So I'm not gonna look anymore because I don't want to ruin it. The thing about the detailed reports on the Viopath technology phone calls, it gives the phone numbers of the callers. I'm surprised it's not redacted, but we do have things like inmate hung up, the other person hung up. That's interesting. So it shows who hung up, who timed out. How much is being paid. It was done by prepaid cards, of course, all of them are. I don't know what energy means. If anybody knows this. Oh, she has spent $1,255.31 in jail calls that year. Oh, well, during that time. Oh my gosh. It would be so bad. Honestly, I do have a problem with showing this because there's phone numbers that were dialed or dialed in, and people can get those phone numbers and call them. Oh, I'm a little hesitant to show this, but I can give you information off of it. Brian's alimony? Possibly. But yeah, but see, most of her phone calls are $2.18 each. How is it $2.18? 0 cents free call. Okay, that must have been to somebody, but you're talking 20 minutes and only pay $2.18. How is that? Unless it's a call in. 73 cents, 44 cents for a 15-minute phone call. That's not correct. Can't be unless it's a call in. Yes, they have. But there is a number that's being called quite a bit. Yeah, well, the thing is there's some of these phone numbers in here that are being called quite a bit. And I could probably figure out which one's the husband, but there's a 407 phone number since May that was called quite a bit. Yeah, as much as I would love to show you these, I don't feel comfortable with people's phone numbers. I'm not trying to be mean, but she's had 1,223 calls. I guess I can figure out her attorney. I guess I could have figured that out. But once again, I'm not trying to. Yeah, 1,878 calls on this one with $2,511. There's two different call lists. What does this one say? One of 20, 2210. This one 1024, 1028, 1028 of 22 to 1028-24. Okay, so there's two different ones. A short one that's 112 pages. The other one's 172 pages. Lawyer Brian, yeah, the girlfriend. I mean, you can call and hear a voice and do a hang up, but I would never. I don't think he is. I think that, he's. What breaking news? Judge in civil claim against Karen Reed has ruled Karen Reed's favor. The civil case will not go forward until criminal case concludes. That is the right decision. That is the right decision because unless she's found they should not be able to put the cart before the horse, and that's what they're doing in that one. So, yeah. Brian is still at for some reason. Well, unfortunately, as in my situation, I had to stay connected because of the children. I did not have a choice. I did not have a choice at all, and that sucked. Just because someone goes to prison does not mean that they no longer have rights to their kids. I'm going to shut the door real quick. There we go, baby. Sorry about that. Oh my gosh. It's that time. It's either 90 degrees outside in the afternoons and it's freezing in the mornings. Well, today it's about high of 70 something. And my toesies are cold. It's pouring over here. Yay! Send it my way. We need rain, y'all. Here comes the rain again. So I'm checking the weather. My friend said, I just woke up. Holy crap. And I'm like, yeah, good for you. Let me see. Let me see what we got. I think this one might be a better. Nope, we don't got no rain here. Nope, no rain here. Let's see what they're saying about our weather. Well, it does say we will have rain, but not right now. It's 79 degrees outside. About 7 p.m., we have possible rain, about 25%. And then between 1 and 3 p.m., we have about 25% of rain. And we're bright and sunny tomorrow with a high of 76. Perfect camping weather. And I don't have my gear. I don't have my camping gear, y'all. I think she does. I think that is so true. I don't disagree with that at all. Yeah, I need to go get some nice winter socks. Every year I buy a new couple pair of winter socks. Yeah. Yeah. Well, this big front thing that was supposed to come through missed us. I was so disappointed. It missed us by about 100 miles. 100 miles north of us got hit, but we didn't. I was greatly disappointed. Mm-mm-mm. And then at 7 tonight, I have to go and do interpreting for my deaf client. So let me find something else for us to watch. How about that? So I may have to be here 9 Eastern. Oh, that's 8 o'clock my time on a Saturday, Jules? Seriously? On Saturday? Are you kidding me? 8 o'clock in the morning. Oh. Do you know what I'm going to do? Since she's been active, I'm going to give her a call. But I will not put her live without consent. So sorry, y'all. Hold on. She no answer. Maybe she'll answer my text. We'll see what she says. If she says no, well, we'll all just sit and comfortably watch. I hope she says yes, though, because I would love to rebroadcast that for her and help boost it. That would be awesome. You'll be up to early. Oh, okay. Well, we'll see if she lets me. I have to ask permission. I have to ask permission. So everybody is still waiting. I've got a lot of windows open here, y'all, trying to figure it out. Trying to find something for us to watch. But watch my live. Luck live? Let me see this again. Tune in Saturday for a sit-down casual interview with the notorious Jules. This is the true crime addict. So this is going to be with RA. Yeah, this is RA's channel. So yeah, I probably won't be able to, but we'll see what they say. It would be nice if I could. Would be fabulous if I could. Okay, so I'm looking to see what else we can watch live. Anybody have a court going on that we can watch? Let me look. Well, the Dodgers World Series. All right, who's in baseball? Who won? Yeah, I know, right? I'm looking. I'll find us something. I always do. Hey, we can watch camping videos, glamping videos. So the Los Angeles Dodgers won, huh? What channel is that, Case One? Oh, I probably can't recast it. Oh, this looks good. How about this? Oh, warm up my toesies. Oh, listen to the fire. Oh, the Dodgers won. I miss having a fireplace. I don't have one. It breaks my heart. The only way I'm going to have a fire is if I go camping. Yep. Yep. As soon as I get a tent, I'm gone. But I have the tent I'm getting is way cool. That's too loud. Oh, you can take a little boo. Let's do this. Oh, boo. I got home last night. I'm going to turn the sound down on that. It's a little bit loud. There we go. I thought that's not his sub channel. That's a different one. That's right. That's right. Guys, dyslexia does a hell on me when you're talking about YouTube. What is his other trial media? True Crime Act. It is somebody different. It is. My apologies. Oh, I so miss having a fireplace. I really do. Are you kidding me? Yeah, that's right. My bad. My bad. People have no idea how hard it is with dyslexia.
Today and continuing well into next week with the opportunity of heavy rainfall and severe thunderstorms. Let's talk about it in this Friday edition of the Texas Weather Roundup.
Boy, that's definitely a Texan.
Good morning. I'm Texas Storm Chasers Boldy-in-Chief David Reimer. It is Friday, the 1st of
Oh,
November,
this Friday.
2024. Welcome to November, ladies
What
and
part of
gentlemen.
Texas you
Unlike the
from?
majority of October,
Johnny,
we are
can you
going to
guess?
be starting off November on a busy
Can you
note,
guess what
and
part
that
of
busy note will
Texas he's from,
continue
Miss
into the
Ronnie?
second week of November, it looks like. Let's just go ahead and get started. This is the North American model for today, tonight, into
Really?
Saturday. Now, we are anticipating an uptick in scattered thunderstorms tonight in the borderland, the Trans-Pecos, into parts of far west Texas and Permian Basin. As we get into Saturday morning and Saturday afternoon, showers and thunderstorms may be aligned, expected to move east across the Panhandle, West Texas, the Permian Basin, into northwest Texas in the Big Country. There is some disagreement in the short-term high-res weather model guidance whether or not we're going to have something like this occur with storms in the Panhandle Saturday morning, moving out by early
And it
afternoon
always misses
with
us.
additional storms firing
It
up in the
does
Permian
before it
Basin
gets
late
to my
Saturday
home.
afternoon. Or if
Will
we're going
do.
to have a larger complex of storms continue moving east and then eventually
So that arrow
southeast
point
into the Big
is
Country,
right
the
where
Contra
I
Valley,
live.
North and Central Texas tomorrow
Right there.
afternoon and evening. At this point, we're taking the North
There's the
American
arrow
model
right there. That's where I live.
verbatim with its timing and
Mhm.
threat hazards. Let's go ahead and take a look at the severe weather outlook
Right there.
from the Storm Prediction
Right there. That's me. Right there.
Center. There we go. I had to press a couple buttons to find it. All right, here's the severe weather outlook for tonight into
See that
Saturday
junction?
morning. The
See,
Storm
right
Prediction
there.
Center
Right
indicating the
there.
potential for
That's
isolated
me.
severe thunderstorms
Right
tonight
in that
into
little
Saturday
place.
morning. The
Right there.
borderland, the Guadalupe Mountains, the northern Trans-Pecos, into the western
Take that.
northern sections of the
Take what?
Permian Basin, West Texas, and the
Take that.
Panhandle.
Watch
Just like we showed you on the North American model graphic, the potential for scattered storms growing upscale into a squall line, moving east tonight out of New
Turn to
Mexico.
yellow.
The potential for localized damaging wind
Are
gusts
you
over 60
over here
miles
by
an
the
hour.
Costco
Maybe
or the
some
Amarillo
dime to
yellow?
nickel
You don't
quarter-size
have to give me
hail,
any more detail. But
and
which
the overall
yellow?
tornado threat looking quite low tonight into tomorrow morning. Now, as we get into Saturday afternoon, this is going to
Are
be
you in the orange now?
dependent on what happens tomorrow morning, how the overall line of storms tomorrow morning
Tennis
evolves,
ball size hail?
where it ends up moving, and how
Dude, I need
quickly
to go
it
storm
does
chasing
so.
tomorrow. You're in
Based on
Amarillo?
some of the current data, it
So
looks
when
like
it's
we may have an
snowing,
outflow
you're not
boundary
going to
generated
camp?
by these storms
You go
tonight
camping with
that
me?
sets up near Interstate 20 Saturday
Tornado.
afternoon in the Permian
Tornado
Basin,
with
the
me
eastern
blow.
Trans-Pecos, the western portions of the Big Country, west central Texas. If that occurs, that corridor could be a zone of slightly enhanced severe weather potential with a potential for isolated supercells capable of damaging hail, strong winds, and perhaps a few tornadoes. However, if we end up having just a cluster of storms move through, it washes everything out. We may end up just having a messier storm mode where we have line segments and additional thunderstorms developing Saturday afternoon into Saturday night, moving northeast into the Panhandle, northwest Texas, and Oklahoma. Regardless, either scenario will have the potential for
right there.
for a low threat of tornadoes, damaging straight
That's
line
right
winds, pocket change size hail, and heavy rainfall. Truthfully, we'll just have to see how things evolve in data later this morning, this afternoon, and we'll get you an update as we get into later today from meteorologist Jason Cooley, and then we'll be doing Texas Weather Roundup videos throughout the weekend as well. We're back to that again. Oh, yay. I'm so happy. I'm being sarcastic, by the way, if you couldn't tell. All right, let's take a look at a longer range because beyond this weekend, we have more to talk about as we get into Sunday. Scattered showers, maybe some storms with heavy rain. Eastern portions of Texas, eastern half of Texas, you can kind of see trying to quiet out for a few hours Sunday evening. More showers and storms as we get into Monday morning. And then eventually we're going to see a cold front dry line move east with the potential potential for scattered severe thunderstorms Monday afternoon,
More
eastern
in
third of
Arkansas
Texas.
and
Those move out
Louisiana.
and, generally
There you
speaking,
go.
exit the state of Texas probably, if this is right, sunrise Tuesday, leading to a low
See, we
impact
get
weather day
nothing
with
here.
mostly sunny skies
So you
across the state of
right there,
Texas for voting.
up there.
We did an early vote already on Tuesday. The potential for scattered showers return on Wednesday. Notice we have southeast winds, could be a bit windy.
We
And
ain't
then as we get into
nothing.
Thursday and Friday, our next upper level storm system comes on in from the west, and that will probably have more showers and thunderstorms associated with it. Busy weather. Here's the latest Weather Prediction Center
Yep, see, I'm in the light
quantitative
green
precipitation
always.
forecast, QPF. I may not have
That
even
gonna
said
be
it right.
nothing.
It forecasts rain totals 7 a.m. this morning
Now,
through 7 a.m.
you
Wednesday, the
could get
6th of
about 2
November.
inches up
You
there,
could
Miss
see
Debbie.
parts of northwest Texas, Texoma, the southeastern panhandle coming off the Caprock. We could see 3 to 5 inches of rain, locally up to 6 inches of rain. The potential for a corridor of 5
Dang,
to 8 inches of rain
7 to
up
8
Interstate
inches of rain
44
right
from
there,
near
y'all.
Wichita Falls
That's 7 to 8
all the
inches
way
right there.
towards south sides of Oklahoma City. That would
They're
result
gonna
in
have some
flooding.
flooding.
The potential right now, West Texas. Well, let's go this way. The potential for 1 to 4 inches of rain. West Texas, the big country. Texoma, North Texas, the Arklatex, Northeast Texas, East Texas, the Brazos Valley, Southeast Texas, the Golden Triangle. And then we're looking at about Saturday
See,
next
this is
week,
what
it
I
looks
want
like.
to see.
All right, we're going to let the upper level jet stream pattern here play. You can see one system kicking in this weekend. It goes
Yep, I'm
bye-bye.
gonna miss it.
Technically another system on western 60% of the state, southeastern third to 40% of the
Yep,
state. We're looking at
79.
80s to near
It's
90
gonna be
degrees
a low
as we
70s.
go into Saturday. Warming up a bit.
And of course,
Southern
Miss
half of the
Miss
state back in
Ronnie
the 80s. Northern
is
half
gonna
of the
be
state
flash flooding
70s. As we
up
go into Sunday, we're going to see
more
mostly
towards
70s to 80s across
where
the
my arrow
state,
is
with the
swinging.
exception being
All of there.
90s in the Rio Grande
Possible
Plains,
flooding.
South Texas into the
Now,
Rio
Miss
Grande
Ronnie's
Valley.
way down in here
On
somewhere.
Monday,
It's gonna
cold
be high
front
in the
starts
high
moving into the
80s.
state. Highs
Getting over
dropping
there,
into the
possibly in
40s
the
and
90s.
50s in the Panhandle, West Texas, as we get into Monday afternoon. Elliot, again, we're expecting some
I'm
continue
just gonna
into
get going.
very much.
Okay.
Anthony R. Pelosi Jr., thank you very much.
Well, I like the tone of his voice. It's just the accent is getting to me a little bit. Y'all, just because I live here don't mean that I talk like that. And if I do, Lord help me. Lots of rain for you, Miss Ronnie. Oh my gosh. Lucky you guys. I ain't getting no rain, y'all. And see, it comes down from the north and it gets almost to us, like within 10 miles of us. And then it kind of splits. Just the way the land is, which is called the natural topography of the land. And unfortunately, it has to be a ring dinger. I mean, we're still dry as a bone. I mean, my ground is cracked in front of on the side of the house. And so uh-oh. I don't know if I could play this one. SKR. Does anybody know SKR? I want to know what kind of cancer Sarah Boone had. And I want to know. Well, you got your east folks and you got your west folks. You got your north folks and you got your south folks. They all have a thick accent. Yeah. Miss Andrielle lives up in the corner that tops in with Louisiana and Arkansas. Mm-hmm. What is it, about an 8-hour, 9-hour drive to my house, my dear? She's been to my place. Uh-oh, 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 uh-oh. Here we go, y'all. Gosh, that fireplace sounds good. I got to stop it, making me too relaxed. About 6 hour? Yeah. Yippers. Oh. I have to show y'all this. Look at this. Look at this.
These are the most infamous female inmates serving time in Colorado. Part 2. Malika Griffin was a chemist that was more focused on her work than socializing. Since she was such a quiet person.
I'm sorry. I just saw that orange jumpsuit and had to go there. Holy Moses. Wow. I was trying to find, let me see if I can find my glamping tent. I want y'all to see the tent. The tent. I know people don't care, but I'm just trying to do something. What, Sensei? 7.5. It depends on the route that you take, and it depends on the highway, or if you take the back roads. Sometimes if you take the back roads, it's so freaking cool. You can cut some time off if you know where you're going. We got something going down. Well, it is almost 3 o'clock their time. I'll share this. This is the tent. I won't share sound because I don't want to get a copyright. Come on, I don't want to see the woods. So you can have the sides open like that. You got plastic or you got the mesh, either one. And it airs up and it airs down. You can put a stove in it. But see the way it, look at that. That's one, isn't that cool? Big tent. I want you to see how it goes up. See, I have rheumatoid arthritis. There is no way in hell I can feed all those things through, and no. Nope. If that skinny mini can do that, I sure in the hell can. There's movement, but they went back to the seal, guys. See? Look, see? Let me speed it up. Y'all don't want to watch this that long. Oh, she's going to do it the hard way. Oh, hell no. I have electric. There's an electric pump. But anyway, it airs up. I could put my whole car in it. Take out that metal section, go right on in. If it starts hailing, see, what's nice is I can take that middle section out and put the hard plastic in, like you do in the front, and then I could pull the car in and get it mostly covered. That's a good thing to think about. I never thought about that. But, yeah. See, so you have the mesh, and then you have plastic. So either one, you got some sunroofs in it. I like the ability to go open, and I like the ability to close it. And I like that I can see, like if I go to powwow, the second room where she's standing now, I would put the door here and leave the front open, and then that way people can, I can sit out in the front part with my little fire pit and still be covered and have some people visit. Be able to. This is a 4-weather tent. Now, if it's baseball size, no. But I've seen videos with people who've gone through snow and hailstorms in that tent. It ain't fun, but it is. I want the carpets, and you can only get those in China. I want those carpets. Look, they zip up. I want the freaking carpet, and I can't find it. Anybody good at finding stuff? I need that carpet right there for that tent. And all of this is from China. But you have the thing over here for your air conditioning that's behind her. Yep. And then over, so that's your air conditioning vents here. And that's a queen, or at least a full. I think that's maybe a full. But look how much room it is if you can put a full bed in there. My gosh, y'all. It is crazy amazing. And watch what she does. I mean, now I'm not going to be like this. But this is glamping to the mat. Look at the fur. I'm all like, that right there is a $4,000 power based system. We ain't having that. We may have that part, but we ain't having the dual. Heck no. I don't have that kind of money. But see, they get all this for free. See, all of this, they're demoing. They do this for a living. So, of course, they got the best of the best. But isn't it nice? You can have your stove. Yep. So anyway, just kind of nice. Yep. And it's funny to watch them because they sit there and they look, they sit there and they eat. They just. All right. I have to say this. I don't know what part of, I'm going to say Orients that they are from, but the videos that you watch with the Oriental, Korean, Japan, wherever, they have some of the best camping food I've ever seen in my life. I mean, they make egg rolls. I mean, anything you can make in a restaurant, they're making here. I'm like, oh my gosh, I can't cook like that. Or I don't know if I want to cook like that doing camping. Give me a good steak, potatoes. I'm good to go. Well, shouldn't have those anymore. Asparagus wrapped in bacon. I'll eat that. But they're so proper. Asian. Thank you. I couldn't pull the word. That's my dyslexia. But the Asian countries, they are so tidy and needy and organized. That's a sink over here. You squeeze that bulb and the water comes out. They have a jug outside the tent that has all the water. And you can wash your hands grinding her coffee. I'm like, dude. It's raining, of course. And here we go cooking again. Yeah. But I'm like, just this burner system alone is like $200. I'm like, some of the stuff they use is like astronomical. But then again, we got Judge in robe, y'all. Bye-bye camping. Try glamping. But anyway, that's my tent. I'm waiting to get it. Come on, get the sound on, y'all. No red meat. Actually, they do. Some of them do. One of them took a steak and cut it and sliced it real thin and then cooked it some more in individual. I'm all like, okay, we're waiting. I wish you could see the looks of my pupper laying down. I mean, sitting down with her head in my lap. Mommy. I'm like, what? I just potted you. Oh, she's in something different. She is scared to death. And unfortunately, I have a suspicion that they found her guilty of something and she will be going to jail, prison. I don't know how she'll do in prison. Gosh, that would be a nightmare. If I had her money, I used to see that mark on her right there. I had one. I didn't have the money and I had it cut off anyway. I had one of those, very small. You can put a little beauty mark thing. I took it off. Got it. Gone. This is the burn pile melody. It depends on where they put her in prison. Depends on what population they put her in. And being an older person, she will be a target at first. Sorry about that. She could very much be a target. She'll go through the solitary confinement. She'll go through the watch. She'll go through all that. The unclothing and the coughing and the whole 9 yards. It's horrible. You know, you can be a tough woman until you get there. Then it's a whole nother story.
The thing
Just saying.
I had to go to that I hope no one ever has to go through. And when I got back in the office, the bailiffs actually stuck their head in and said that the jurors planning on working till 5 o'clock. I wanted to bring them out and get no information about where they are, but just to tell them that folks in the building start getting nervous at this time, and the captains come up to me about people staying late and securing the building and whether anyone wants to come back tomorrow and those sorts of things. So I'm going to talk to them about that and ask them to give us some idea. I want them to stay in here and work as long as they're going to work. And I'll stay with them as long as they need to. I have not talked to them about the alternates wanting to be called in if they have a verdict, and that from the moment they tell us they have a verdict, when they receive one, that it will be a minimum of 30 minutes before we have it, because I know y'all have family members that are going to want to be here. Other folks that have worked on the case. I expect the DA's office is going to reach out to some of the deputies. I believe the sheriff wants to be here. So it's going to be 30 to 45 minutes before we gather everybody here. So if they don't believe they're going to have a verdict.
Y'all, I got a call that they reached a verdict, and my ex-husband, I literally was 8 minutes away, and they were reading the verdict when I got there.
This afternoon,
they don't
want to work till 5 o'clock. I may tell them that I'm going to cut everybody loose at 4, and they can stay in here and keep working, kind of like we've been doing, and then find out whether they want to come back tomorrow, which I'm going to discourage. But if they want to, that's what I'll do. And then if not,
Monday.
I'll report back on Monday. But I'm going to kind of give them that kind of guidance
for
and
one
see
more
what they are doing.
free
I think
weekend.
you have a conflict in the morning or something. Someone told me you had something doing. But I have a conflict for today, but I have multiple conflicts for today, but we are here. I'm going to.
You're not going to encourage them to keep working just tonight until they reach a decision.
Correct. I'm going to let them make that decision. I will stay here with them as late as they want to.
We will too.
But they have indicated that they want to break around 5. I want them to tell me that officially. And if they do, I'm going to tell them if they don't have anything by 4, I'm going to cut everyone else loose for the day, and they are free to stay here and continue to work. Because if that makes, to the extent that that makes sense. All right. Okay, go ahead and bring them in.
Oh, I wish I could get that to work.
And if they have any other requests.
They bring the jury.
Today, if they do.
Bruh.
What was that? That sounds like RA, doesn't it? Is that the judge? Judge playing drummer? Boy, I got to tell you, that's a sucky place to be. Guilty or not. Doesn't matter guilty or not. That's a sucky place to be. She may have this weekend to say her goodbyes. I sure in the hell would.
It must be much warmer in the jury room than it is in the courtroom.
Ugh. You were complaining you were hot earlier. Pick a side. Any side. Everybody in their long sleeve.
All right, ladies and gentlemen, I just wanted to chat with you a little bit about your deliberations. I am not in any way trying to rush you. I want y'all to take as much time as y'all need on this case.
But
what I want to talk to y'all about is bailiffs came back and told me that y'all wanted to work till about 5 o'clock, which is fine. But I want to talk to you before that to update you on a couple of things I don't think we've talked about since I dismissed y'all to the jury room Wednesday. First, when I spoke with the alternate jurors and dismissed them, they are still on call. They all want to be here for the verdict, understandably so. They've invested 4 weeks of their time, so they want to be here when y'all reach a verdict. There are numerous other interested parties, witnesses, family members who also all want to be here when a verdict is reached. Some of them are on site and some of them are off site. It will take no less than 30 minutes up to 45 minutes for us to get everyone here for the verdict. So I want y'all to understand that there will be a delay once y'all reach a verdict and the reasons for it. So that's the first thing. The second thing is this is about the time of day and week where folks in the building start getting nervous. Not because of y'all, but because they have to start getting in people to keep the building open.
Of course.
People think I have a lot of control. I have very little control. I have significant powers of persuasion, but I have to get permission from court staff to keep the building open. I have to let the people at the county commissioner's office to let them know that we're going to keep the building open. We have to talk to the person who regulates the thermostat to either keep it on or off or turn it down or whatever. So I want y'all to continue to work here this afternoon and this evening as long as you want to. I would like to, at some point, to be able to tell court staff whether we need to stay. They need to have additional personnel on call to come in and keep the building open and notify anybody else that may happen, and whether or not. So I want y'all to kind of assess for yourselves whether y'all are close or not, whether y'all want to continue to work throughout the evening, afternoon, whether y'all want to break around 5 o'clock, whether y'all want to keep going till about 6 o'clock or later. Again, whenever. I'll be here till 2:30 if that's what you want. All right. The lawyers will also do the same. They are not in a rush to leave. They want y'all to take as much time as you want.
Late.
So I'm just letting you know, you tell us what you're going to do. We will make appropriate action. If y'all do not believe that you're close to reaching a verdict today, but you want to stay and work till 5 or 6 or 7, that is perfectly fine. Kind of like last night, I would tell them, we'll come back on Monday if y'all reach a verdict tonight or tomorrow. So that would be the other thing, is I have kept the building open on Saturday. I've had many juries come back on Saturday morning and deliberate. I'm not going to encourage that, but I will go along with that if that's in fact what you want to do. When we've had juries come back on Saturday, a lot of times they want to come back at 10 and work from 10 to 2 and then take the rest of the afternoon off. Again, that is up to you. But what I would like for y'all to do is kind of go back, talk among yourselves, and give me some report to the best that you can, what y'all would like to do for the rest of today, whether y'all anticipate maybe getting a verdict tonight, whether you do not anticipate getting a verdict tonight, whether you want to come back tomorrow if you're going to continue to work, or whether you want to come back on Monday. Is that somewhat clear? All right, if y'all could do that, and y'all can just give me a report in writing to the bailiff, and then I'll inform the lawyers. If y'all want to continue to deliberate, do not believe that y'all would get a verdict today, I would probably tell the lawyers and the family that they could be excused around 4 o'clock. If there's any questions or evidence that y'all want to review today, let us know in the next 30 minutes, and then we will do that, and then we will excuse whoever for the day, okay? So if y'all would do that and then give me a report back, I'd appreciate it. Thank you. All right, any issues with any of that? All right, we'll hang loose until we get some report from them, and then I'll update y'all, and I'll give y'all some suggested course of action. I'll bring y'all back in. Okay, then I'll just.
Oh, yay!
I mean, I know the folks in the back are going to want to know too, because they have the watch party going on
We've been
online.
here so long that I've lost my voice. I've turned into a chipmunk.
Somebody's hosting a verdict watch. Something.
What?
I'm quite astounded, actually.
What? Let's go back.
Online. Watch some report from them, and then I'll update y'all, and I'll give y'all some.
We got to hear that again.
Suggested course of action.
I got to hear that again.
I'll bring y'all back in. Okay, then I'll just. I mean, I know the folks in the back are going to want to know too, because they have the watch party going on online. Watch party. Somebody's hosting a verdict watch. Something.
A lot of us are.
I'm quite astounded, actually.
Let me get my live captioning. Oh gosh. I want to see if that picks up what they said in the
A verdict watch. Something.
because sometimes it picks up what it can't on the.
I'm quite astounded, actually.
No, nothing specific. Whoop, whoop, we're one. He's like, folks, really? Hey, do you know how many people have learned about how the law works by watching us? Do you know how this has boosted people going into the legal field or criminal justice system? I mean, this is a good thing for you, dude. Don't knock it. We like you. Think of it hard to just say quiet. Here's my thing on this. Again, I'm struggling with knowing exactly. I don't have a straight answer for her on this. I don't. Because I don't. The problem I have is when they end this at 5, we'll go into the Sarah Boone. Then I'll end that one and go work at the other place. I have had no homework done. I can't. I got to get some work done. I got to start working on my assignments. I just realized. Let's see what I can do. Hold on. Her quilt? Don't you love it when you hit a 0 and they hang up on you? I know, right? How rude.
To place an order or let us know you have arrived.
I hate these menu options. They suck. I don't want to get in trouble. Okay, I'm good to go. Disaster averted. We will probably, my homework assignments? Are you kidding me? You really want to know what this is? Oh, girl, y'all asking for it. Let me see. Where is it? There's boom. I gotta find it. Nope, I don't want that. I got about 10 things up here. Okay. I have. Okay. Groovy Cheryl. Y'all. Okay. I'll share this page. Here's what I got to do. Okay. Heads up. I have to submit a discussion board assignment due Friday midnight. I got to read through the chapters of everything. The discussion is this. This is my discussion question. Are you ready for this? What is a gang? Are gangs the same as organized crime groups? Nope. Are gangs highly structured? Why or why not? Support your answer. Your primary post must be 250 words in length, and I must respond to 2 other students. Then my other class, well, that's transnational crime, by the way. The other class is, okay, I got to take a quiz. I did. The assignment and a discussion tonight. Okay. So, I have to pick 2 of the 4 questions and write 2-page report. First question. Why don't I move it over here so I can not be reading sideways and I'm looking at you? First question. Explain the elevation of the organizational theory, including scientific human relation systems and the bureaucratic management theory. Or, what does communication mean? What is its importance in organization? Explain culture cues, nature, and uniqueness of police communication, and some of the major barriers to affect communication. Or objectively assess what kind of leader you would like to be. If it is helpful, use the managerial grid. Is it an effective style? What are some of the possible advantages and disadvantages to this style? Or the last, what kind of world did the X, Y, and the next generation, XA, something like that, I don't know, grow up in? And what advantages and challenges did these persons pose to the criminal justice workplace? In the criminal justice, what are the policies and legal implications of the younger generation pertinent to tattoos and generally non-traditional appearance? Oh, thank you. You're so amazing. You really are, Tori. I really, 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 really. So, y'all wanted to know my homework. Yeah. Why were you not posting any comments? And with these 2 questions, I must have a minimum of 4 paragraphs, minimum of 30 words. Yeah. Y'all still want to help? So 10 p.m., I got to have that assignment done. Midnight, the other assignment. done. And then Saturday, I have by 10 p.m. I also have a discussion that I'll do tomorrow. Are you the one that Jules is going to be on? Are you? I don't know what channel you're referring to. Bless me. I'm so sorry. True Crime Addict. I tried to send message. I didn't know if it got through. I don't. Oh, okay, wonderful. Great. Are you okay with me? You can tell me no and it's fine. I just wanted to boost you. True Crime Addict 8. Oh. I apologize. Let me get there. There you are. Perfecto. Yes, but I didn't. Where did I leave a message? I don't know what's happening. My apologies, beloved. Yeah. Catatina, I posted the question in Jules' thing. Let me go look at her comments. I didn't post it on your YouTube, or maybe I posted it down here. Or maybe down here. I did it and it's not showing up. Why not? Why can't I see the replies? This is frustrating. I'm in Twitter or X. That's where I posted the comment. But when I click on it, why can't I see the responses? I can't see responses for some reason. I apologize, love. Well, it may have been through that link, but where in YouTube? Because let me go to lives. Let me see there. I have no idea, dear. Forgive me. I'm having some challenges over here. There it is. Thank you very much, my dear. Wait a minute. Let me get there. Yay! You're an angel. Okay, I will get up early on Saturday tomorrow. I'm usually not here until 10, but I'll be here because it's 8 Central Time, and I will put you guys out there. I will happily blast you out there, love. Un momento. Sorry. We're good. Had to take that. Oh, so I will hop on. I will set live tonight.
All right. It's my understanding y'all want to go ahead and break for the day and resume deliberations on Monday at 9 o'clock. And that's perfectly fine. I'm sure y'all are tired. I know I am. I will tell y'all, just similarly as I was telling you before I dismissed y'all about gathering folks up, that's going to be an issue. I have an additional issue next week in that I have court scheduled every day for an entire day for the entire week.
Oh, crap.
That's not your problem and not your concern. And it's not the first time I'll be juggling a jury and other matters.
I did too, Ronnie.
It will just take time for me to, because I don't think we have a free courtroom for me to use for my other calendar. So it'll be me sending whoever's in the courtroom out and then bringing whoever needs to be here for whatever we're taking up with y'all in. But that should not, don't let that impact anything y'all are doing other than what I've told you about. If you have multiple questions, multiple things you want to review, do that. It'll take somewhere around 30 minutes for us to get everybody back in here to do those things. So continue to work while you're doing that, or it's a good time for y'all to take a break, go get coffee, stretch your legs, whatever. It is, again, critical, and this is probably the most dangerous moment, especially in a case of this nature in terms of somebody communicating and reaching out to you. We have obscured your information so nobody knows outside who you are. My bigger concern are the people who know you, who are part of your inner circle that knows that y'all are in this case. Do not let them talk to you about the case at all. To the extent you can stay home and sleep and watch college football tomorrow. Don't have my cup. But to the extent y'all can do that and stay away
College
and out
football,
of
man.
public eye, that would be fantastic. If something happens, remove yourself from the situation immediately. Let the bailiffs know first thing, and we will talk to you and address it first thing. As long as you immediately remove yourself from the situation, no one says anything of significance to you, that's fine. And I know that you're not going to intentionally do that. But again, be especially careful if you use social media. Be very careful if you're on it over the weekend. If you like to review news,
Parties.
this has been picked up by local news, been picked up by Atlanta station news, and it's been picked up by various national news media organizations, including the folks that are in the room in the back. So just be especially careful. Don't talk to anyone about the case. Look up anything about the case. Look up anything about the law. I'm not going to say, like I said, if you're watching Law and Order or something like that, that's fine. Just remember that what they're talking about may or may not have anything to do with the law in Georgia or how things work here. Y'all are free to go back and deliberate as long as you want to for the rest of the day, or be dismissed for the end of the day. I'm not going to give you any additional instructions or make you come back in here. Any questions, comments, concerns about anything from y'all?
No.
All right.
They're coming back.
Y'all can be excused. Have a good weekend.
At 9.
Go Dogs.
Go Dogs. We know who he's rooting for. His courtroom. He can say that. No. Monday, 9 a.m. They have the weekend off. She keeps looking at that camera.
All right. And with that, y'all can just be on call starting at 9:30 like we have done the last couple of days.
Was it tomorrow?
And
no.
I'll let you know when we know anything. All right.
Oh, let's rewind that.
And
Let's rewind that. I thought he said Monday. They're going to go for tomorrow? I thought they said they had the weekend
if they want
off.
to, that's what I'll do. And then if not, have them report back on Monday. But I'm going to kind of give them that kind of guidance
Report
and
back
see
on
what
Monday.
they are doing. I think you have a conflict in the morning or something. Someone told me you had something doing. But
Let's go back. Oh, they will return tomorrow? Wait, how can he say go watch football? Well, we'll be here at 8, so we'll be live. Gee gads. I guess it is tomorrow. It is always their schedule, too, a big part of it. It is their schedule, not his. Look at that flap. I love it. It is their schedule, and that's way for a lot of courts, although
All right.
it just depends.
It's my understanding y'all want to go ahead and break for the day and resume deliberations on Monday at 9 o'clock. Is that correct? And that's perfectly fine. I'm sure y'all are tired. I know I am.
He said Monday at 9.
I will tell y'all, just similarly as I was telling you before I dismissed y'all about gathering folks up, that's going to be an issue. I have an additional issue next week in that I have court scheduled every day for an entire day for the entire week. That's not your problem and not your concern, and it's not the first time I'll be juggling a jury and other matters. It will just take time for me to, because I don't think we have a free courtroom for me to use for my other calendar. So it'll be me sending whoever's in the courtroom out and then bringing whoever needs to be here for whatever we're taking up with y'all in. But that should not, don't let that impact anything y'all are doing other than what I've told you about. If you have multiple questions, multiple things you want to review, do that. It'll take somewhere around 30 minutes for us to get everybody back in here to do those things. So continue to work while you're doing that, or it's a good time for y'all to take a break, go get coffee, stretch your legs, whatever. It is, again, critical, and this is probably the most dangerous moment, especially in a case of this nature in terms of somebody communicating and reaching out to you. We have obscured your information so nobody knows outside who you are. My bigger concern are the people who know you.
They're returning Monday.
Are part of your inner circle.
Okay, guys, they're returning Monday, not tomorrow. Monday at 9. So we'll be back tomorrow with True Crime Addict 8, Catatina Pickerel. Hopefully I said it right. And Miss Notorious Jules. I will be boosting that podcast, YouTube live. So I look forward to having y'all come back and join us, and we can support them. And then we will be then back Sunday for the Sunday night live. I gotta figure out what the heck. Do you know what, guys? I'm gonna change it. Y'all gonna hate me. We're doing Boone on Sunday Night Live because there's more stuff that's popping up. There's more stuff that's popping up. So we're going to, I'm deleting that broadcast. We will do the Boone on Sunday Night Live because I've got more stuff. Oh, thank you. She's so hateful. Ha, 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 ha. Okay. Hey, ADHD, how are you doing? Hello, humans. So, Jury Satter, who told you? Jury's not going to be here Saturday. He said Monday, and he talked about football on Saturday that they could watch. So, but guess what? If they do, I'll be here and we'll be up live. So just keep an eye out. If they confirm tomorrow, I'll be up tomorrow. We'll be on tomorrow. Okay. I'll already be here for the True Crime Addict. Is it the or true? I apologize. 8. One thing that the new people need to understand. I'm dyslexic as hell. And it's really hard, True Crime Addict 8, for me to memorize new stuff like that. So my apologies, but blessings to you. We will be on tomorrow morning with them. So if they are live tomorrow, then we will be. If not, then we won't be. But we'll be here anyway, no matter what. Okay? Yeah. I really need to get off and get some homework done. I got a lot to do today. So that's the truth. So we will see everybody. I could have sworn he may have made a mistake, y'all. He may have accidentally made a mistake. I'll go and pull the court records and see what time they have it slotted for, because they usually put it in there if their records are up. But it's been a long week, wonderful week. I thank everybody for joining. We've made a lot of new friends this week. We've had some good, we've had some bad, mostly awesome. And you guys are the awesome part. RA said, well, you know what? If it's tomorrow, we'll already be here. So no big deal. We won't miss it. I promise. Oh, Zach, you're awesome. You still owe me a cup of coffee. Along with a night fishing. And you never respond to that one. Yep, I'm going to hold you to it. I might even bring you a mannequin with white legs. Oh, if you don't know what we're talking about, go watch some of Sarah Boone's stuff. Let's go watch some of our Sarah Boone. You'll quickly figure out what that means. By the way, if you see Zach kissing his fish, we know who. Yeah, I'll even get a little Baltine hammer and just bang on it to make it look like cottage cheese. That's right, Jelly Bean. Okay, guys. Oh, now it's time for me to stretch my legs, have a comfort break, give my puppy a comfort break, and then get to work. He is, isn't he? I mean, all right. Blessings. We'll see you in the morning, bright and early. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.